What's up, Death Warders? Net Narrator here once again to record some more Epstein. And last time we were continuing on with this massive, over 400-page interview with, I believe, the U.S. Attorney, the head of the U.S. Attorney's Office, that gave Epstein essentially a light sentence in 2007. So we're looking to finish that today and hopefully do a few extra things within Dataset 7. And then likely the stream after that, whenever that will be will allow us to finish Dataset 7. There are 12 datasets altogether. Not all datasets are created equally, but this is a big one and a very informative one as well. But first of all, as always, I fully intend for any proceeds gained from this content and my other Epstein coverage to go to Speak Out, Act, Reclaim, SAW, which is founded by Virginia Giuffre, one of Epstein's victims. One of the first ones actually to publicly come forward, who is now unfortunately deceased. While the organization is not currently accepting donations, and I was unable to set up any official fundraiser via YouTube, I will donate the proceedings when possible, or to a similar organization if that is not possible. And proof of this will be released when I do so. Now, before we start, I'm just going to point out something else. I got my kitties a blanket, and it's arrived today. So I'm just going to show you these little degenerates. If I don't want to muck up my webcam too much. Hello, Dexter. And Clara, as always, is being an absolute menace to society by making noise, not settling down, and looks like she's trying to go behind my monitor as well, and behind everything, and behind the desk, rather than just on the desk, enjoying a simple life like Dexter here. Dexter, of course, being my black boy. He's a good boy. Hey, dumbass. Clara. Whoop. There we go. There we go. You don't want to go down there. Just sit down like a normal cat. There's even a cat tower. I did originally have it on top of the shelf, but they were just trying to knock it over, and they were making a lot of noise. So, that is life. You're a good boy. Yes, you are. And as yeah, okay, Dexter can chill here. That's absolutely fine. You're a good boy. Yes, you are. Yeah, I don't have favourites though. Clara's great as well. She's very affectionate. Dexter has always been the chiller of the two. So he's less of a menace to society than Clara is, but Clara's great as well. There's a good girl. Anyway, so hopefully with luck, that means they will sit here the entire stream. They won't go back and forth in front of my webcam, and they'll just be chill. You know, I'll give them treats if they're good as well. I always do that after a stream. Anyway, let's carry on from where we were last time, which was yes. All right. No, I'll say again. The format I do it, I don't say Q&A, the questioner and the answerer. I will put on different voices to put that across, and that's better presentation, I feel. All right? All right. All right, it was an issue, and it was one that he raised as soon as he came back. So there was an effort, which he conducted then in redacted absence, to craft an MPA addendum to address that issue. Are you aware that Redacted received a copy of the MPA in November when Ken Starr wrote a letter to Redacted asking her to review the 22.55 portion of it? Do you remember that issue? I remember that the issue was applied to CEOS. Okay. Well, it was. It was appealed initially by letter to Redacted, raising an issue that was new to that had not been raised with you, and that is what led to your letter to Ken Starr on December 4th. I will accept the timeline. Okay. It's difficult without all the documents. Sure. But yes. And at the time that Redacted saw the MPA, he sent a message to Redacted about his view of the MPA, and you didn't see it, but I just wanted to name some problems that he identified with the disposition and get your reaction. To it. So first, he says, I'm not thrilled about the agreement, but he acknowledges that's out of his hands. He says in terms of the charging and sentencing provisions, Epstein is getting a much better deal than the average defendant, with the exception of defendants who have done physical harm to their victims or abused very young children. We haven't seen more egregious conduct because of its serial nature. The area we need to be most careful about relates to the victims. The US should seek to ensure that the plea, which is not giving him serious jail time, provides the best means possible to address the harm he caused to the victims. That generally means restitution and/or therapy. While the agreement provides facility for the victims, the relevant terms still seem pretty advantageous for the defendant, and not all that helpful to the victims. They get an attorney who will be paid by the defendant, which involves at least some conflict of interest. Or they could hire their own attorneys on a contingency basis, and they get waivers from the defendant when his plea would facilitate their civil cases in any event. Then, they still have to sue him to get anything. Most times for wealthy defendants, we make them agree to our restitution fund, and then still provide that the victims can sue the defendant independently if they so choose. Or if they choose, sorry. We always make them clearly admit their guilt. No, please. This is incredibly important to the victims. I would have taken the guy to trial unless the victims were clearly against it. And I don't think most of them are here. He then says to Redacted, who by this time is working for... Redacted, right. So that's the context in which he's addressing it. Redacted specifies that Redacted wouldn't and shouldn't address the agreement. So that... Why was my access? Oh yes, cat bed will arrive today is literally the one they're sitting on right now. Jolly good. So that's the context in which he's addressing it. Redacted specifies that Redacted wouldn't and shouldn't address the agreement. So that the issue that was then before Redacted, put there by Ken Starr, was whether this 22.55 scheme or scenario set out in the MPA was appropriate. It appears that she then sent that back to you to address. Right. But as far as Redacted commentary on the MPA, if you had been aware of this perspective at the time you were, that you and your people were fashioning the MPA, would that have been helpful to you in deciding how to proceed? So may I? Yes. Okay, I assume you've read the whole thing, but let me just I have. And so a few comments. First, let me say he was part of the September meeting. And to my recollection, these perspectives... So at least the outlines of the agreement were disclosed at that meeting, and I don't recall this type of communication at that time. Okay. I also recall that there was a lot of back and forth around this restitution fund concept, and our perspective was that the restitution fund puts the victim at a disadvantage. Because, let me try to recreate. I don't recall the details, but I can recall that there was a perspective that the restitution fund, put the victims at a disadvantage, and there is some reference to, was it an Alaska case? It's called the Redacted case. Mr. Redacted. Redacted. The witness. I'm sorry? Mr. Redacted. Redacted. The witness. Redacted? Ms. Redacted. Redacted or redacted? The witness. Redacted? By Ms. Redacted. Yeah. And so to the extent that there were better ways of crafting this, that certainly would have been highly relevant, because to my recollection, we were not wed to any particular way of crafting it. The intent of the 22.55 was to come as close as possible to putting the victims in the position they would have been had he been tried and convicted federally. And so the answer to your question is yes. That would have been helpful. Okay. As you set about addressing the 22.55, you consulted with Redacted. Do you recall that? I recall consultations. I don't recall that it was specifically with Redacted, but did you know her? Yes. Okay. And do you recall the nature of your interaction with her? I don't. I know from contemporary review of the record that there was an email from her. It's 41A. 41A. And what I want to ask is simply, 41A is an email in which you ask, you note to Redacted, who was Redacted, right. One of her deputies, she oversaw CEOS. She, Redacted, mentioned to you that Redacted was looking at this, which is the 22.55. 22.55, she contacts her counterpart in the civil division. Redacted. And there's an email from him, which is the second page of this exhibit, which he copies you on. So my question is this the extent of your interaction with Redacted on this issue? 12 years. Okay, after the fact. I don't remember. Okay, alright. In Exhibit 35, there is a letter from J. Lefkowitz in which... I'm sorry, it's an email from J. Lefkowitz. Exhibit 35 to you, and this is substantially later, but it has a sentence that... or a phrase that we'd like to ask you about, and... Alright, it's highlighted at the top. It says, back at the beginning of January, when we both agreed that there were significant irregularities with the deferred prosecution agreement, you called a timeout. Is that accurate? Did you and he agree that no? There were significant irregularities? No. Okay. And if I could, there are several instances where, not just to me, but to other people as well, G recharacterizes conversations. Recharacterizes them inaccurately, or misleadingly. Alright. What I recall agreeing to at some point is that there was an appeal to the DAG, or there was an appeal in place, and I basically said, I think there was a letter that I sent saying if you want to appeal, go ahead. We're not concerned about this. But that doesn't mean that I agree that there were irregularities. Alright. Or that there was a timeout. I'm part of a department. I'm part of a hierarchy. If someone wants to overrule me, that's okay by me. Alright. So the MPA addendum was worked out, and the defense team continued its sort of multi-pronged assault. In the middle of the negotiations between Redacted and Lefkowitz about the MPA addendum, that's when you had the much commented on breakfast. Correct. On October 12th. And you have stated publicly that perfectly accurate that the MPA was signed and that was a done deal. And so that this was not tied in any way to any effort to influence the terms of the MPA. Fair? Fair. Because the way this was reported was that I negotiated it over breakfast. It was signed, and that's really important. Of course. There were, however, a number of open issues. Yes, right? And in Exhibit 28, J. Lefkowitz on page 2, this is an email to you, acknowledges your breakfast on Friday. This is dated October 18th, and following up on your conversation with him about the day for Epstein's plea. So he knows that you said you didn't want to dictate a schedule to the state. So all I want to note is that when you had the breakfast, there were issues still open that were the subject of discussions between the defense and the U.S. Attorney's Office. And so, no, let me redo that. And so, I guess my question is, while that was a meeting of convenience in a public place, in a location where you had business later that day, a speech, I believe, optically, do you understand the public concern that this was sort of a one-on-one negotiation on pending issues? So I understand how there can be concern. This, it was not unusual. In this case, I actually very intentionally waited and tried not to have one-on-one meetings, but there are other instances where I might from time to time have one-on-one conversations with the opposing counsel. I don't remember the breakfast. I can speculate that one of the issues that was informing this was somewhere around this time, but I can't say with certainty that this was what it was. But somewhere around this time, there arose allegations that Redacted had directed the designation to her boyfriend's partner, or something along those lines. I believe it was a former law school classmate of her then boyfriend. And so I don't remember what the details, were. But I know that was a topic that he wanted to raise, with me. Did he, at that breakfast? I don't remember the breakfast. Okay. You asked me about one characterization of what I said in the record, of that breakfast. I think I responded, Through, or my counsel responded. And they're pointing out that I seem fairly perturbed at how he inaccurately characterized something that I said. And so we don't need to revisit that, but... alright. If you look at Exhibit 27, another sort of point, just to kind of... Alright. Mr. Redacted. Could we... Before we... Mr. Redacted. Yes? Mr. Redacted. Leave. Are we leaving the breakfast meeting? Mr. Redacted. No, this is... The witness. Okay. Mr. Redacted. This is directly related. Mr. Redacted. Okay. By Mr. Redacted. And that is Exhibit 27 in the second email down. It's from Redacted to J. Lefkowitz. The date is October 12th, so that's the same day as your breakfast. Right. And the date of it is not... I'm sorry, the time is 9:48 a.m. Your breakfast was at 7. So this would have been pretty shortly after your breakfast, and Redacted writes to J. Lefkowitz with a copy to you and Redacted, stating that he just got off the phone with you. That is, Redacted just got off the phone with you, and then he finishes a revised paragraph 1, which suggests... I infer from that shortly after the breakfast you had a phone conversation with Redacted about a revision to this paragraph, and that was likely something that you talked to him about. Again, I'm not right. Suggesting that this... Again, I don't recall the breakfast, so I can't say one way or the other. I take your point. I don't recall seeing this. Alright. Well, it was, but you were copied on it. Okay, alright. Redacted, you wanted to... By Mr. Redacted. I just wanted to point to Exhibit 30. Can we back up a second? Mr. Redacted. Sure. The witness. Redacted, I'm not sure whether your concerns are... So, I would only raise the question where, or the point where, based on this, and I don't recall, so I can't speak, but Redacted is saying, J suggests revision has been rejected. Here is our latest, Redacted. And so, there are multiple ways to read this. One is that this was raised. Another is that we're rejecting something that Jay has proposed, and... Ms. Redacted. The witness. Because I was meeting with Jay. I asked that Redacted not reject it until after I met with him. And I'm speculating because I don't recall the topic, but it does appear that it says, Jay's suggested revision has been rejected. Here is our latest. Mr. Redacted. All right, thank you. Redacted? By Mr. Redacted. Can we just go to Exhibit 30 quickly? There's some highlighted language. This is a letter from Lefkowitz to you on October 23rd, 2007, where he recounts, again, the things that happened, or his version of the October 12th breakfast meeting. Yes. Are you at that? Yes. At that point right there, Exhibit 30. Yeah, I'm there. Okay. So in the highlighted language, if you could just take a look at that quickly. Yes. So he is recounting that you had assured him that the office would not intervene with the state's attorney. Now, this is new. We never had. I don't think we've had the evening session before. This is a new page at 6 p.m., but it carries on. Yeah, just pointing that out. So he is recounting that you had assured him that the office would not intervene with the state attorney's office, or contact the civil claimants or intervene regarding the sentence that Epstein receives pursuant to a plea agreement. Yeah. So is he correct in his recounting that? Can you find that for me? Yeah. So again, I don't have an independent recollection. Oh no, I'm looking. Misredacted. Oh, you have it. The witness. For something. I don't have an independent recollection of that breakfast, but in the contemporaneous emails and the contemporaneous record, there is correspondence between Redacted and I, and you all asked for this, and I spoke with my counsel, who then responded, and there's an email exchange where there's an October 20th. This was an October 23rd email. October 23rd letter. And then there is a response that's drafted on October 25th. I don't know if we can find that. From Redacted to J, that specifically addresses the point, and then I respond, Redacted runs that by me, and I respond, I edit the letter and I move it. I sort of emphasize, I make it firmer, and my edit says our office cannot and will not agree to this, and then my comment to Redacted is, what do you think of this rewrite? Is it too strong? By Mr. Redacted. What day was that? That was 2 days after this. I don't know if we can find that in the chronological record. That was October 25th. Let's just take a minute. Is that what you have? Mr. Redacted. Sorry, apparently my ability to separate paper has failed. The witness. Okay, so this is... Mr. Redacted. Oh, I see. The witness. So... Mr. Redacted. Sorry, go ahead. The witness. So, October 25th, I'm writing to Redacted. What do you think of this rewrite? Is it too strong? And it says, Dear Jay, I'd like to take this opportunity to document our conversation of October 24th, which clarifies some of the representations in your October 23rd letter. I write in particular because you indicated that your intent in writing the letter was to memorialize our conversations. Our agreement is limited to blank, 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 ... I specifically want to clarify one of the items that I believe was inaccurate in the October 23rd letter. Your office states that this office would not intervene with the state attorney's office regarding this matter, or contact any of the individuals, potential witnesses, or potential civil claimants, and their respective counsel in this matter, and neither your office nor the FBI would intervene regarding the sentence Mr. Epstein received. I'm quoting Jay's letter. As we discussed and hopefully clarified, and as the U.S. Attorney previously explained in an earlier conference call, such promises equate to the imposition of a gag order. Our office cannot and will not agree to this. It is the intent of this office to treat this matter like any other case. Thus, as is typical, we do not desire or intend to intervene in the State Attorney's Office. The non-prosecution agreement provides sufficient mechanisms to achieve the goals of the federal investigation. You should understand, however, that there are some communications that are typical in these matters. And so I go on. And so my point is, this was pretty based on, if you review my emails and language, for me to write something up saying, what do you think of this rewrite? Is it too strong? And to edit Redacted's language to, our office cannot and will not agree to this. It is not my agreeing with this characterization, but my polite way of saying, this ain't what I said. Let me be clear. And then, again, no independent recollection. This is just based on inferring from the contemporaneous emails. Okay. By Ms. Redacted. What I would like to do is ask a couple of questions in a couple of areas about the main justice review. Okay. Then take a short break, and then Redacted to some questions that are CVRA related. And then we have some summary questions. Okay. Is that all right? Can I, before you move on, can I address something that Redacted was getting at, but it's getting late, so I'm going to circle back to, please, something that I thought you would bring up. Ms. Redacted. Sure. The witness. So I think something to talk about is pre-agreement and post-agreement. I think are different, and one concern that I had, and I certainly shared with Mr. Redacted, was once it was signed, so we had the initial issues with the case. Once the agreement was signed, we now have an overlying issue of, is the agreement binding? To what extent it's binding? And so your question was, why this level of process after the agreement was signed? And I said, I think you'll get back to that. And I think to some extent, there are two parts of that. One is, the office shouldn't be afraid of review. We're part of the Department of Justice and review whether it by main justice or now you all is part of the process. And so, to the extent that they want to appeal to Maine, it would be unseemly to sort of say, don't review us. And I don't think it would help reviewing this, but the second part of it is, if we were to walk away from the agreement, that not only are we litigating the underlying criminal case, but we're litigating a civil criminal issue on top of that, which is, did the agreement bind? And that's something that did inform the exhausting amount of process that they received, which didn't change any of the outcome. By misredacted. Didn't bind what? So, if we were to walk away, well, could we still prosecute? I see. Right, because having signed that, we were now parties to an agreement, and that would overlay any sort of prosecution. And so you had these collateral issues coming. By misredacted. Just to make sure we're clear, are you saying that there would have been a difficulty in declaring a breach so that you could then indict? Correct. And so we'd have to litigate over a breach, because as much as they had collateral challenges, they are very careful in saying, this is not a breach, we would just like a review. And so one of the issues that overlaid the post, that October going forward time period is on top of this. Do we now want litigation over a breach? And so I think that is why the post-agreement time period is different than the pre-agreement. Misredacted. The witness. Time period. By misredacted. But was part of that problem the result of the change from, here is the date that you must comply, to, you must use best efforts to comply? Possibly. I would, whether it was that or others, or other parts of the agreement, we can talk about, but how, once the agreement was signed and they start pushing the date, there becomes a legal issue over, are they really in breach or not? And I understand your perspective. I'm just saying, earlier I said that there was a difference. You asked about the process, and I said from my perspective, there's a difference between the pre-agreement and the post-agreement time period. And much of that difference is informed by, if we declare a unilateral breach, how does this hold up in court? Because now there's a signed agreement that the United States is a party to. And are you saying that part of the reason, or maybe all of the reason, that you continue to give accommodations and process and delay was because of the concern that you couldn't actually win a breach argument? I think that was a consideration. Another part of the considerations are if a party wants to take, Main Justice gave a lot of process. It wasn't just to redact it, but it was just up to the Assistant Attorney General for Criminal Division, to be polite, but it was up to the DAG. And so if Main Justice is going to give them this degree of process, we should be in the position of saying go forward, as opposed to, I don't think it looks positive for the office to be viewed as fearing department review. But were you giving the impression to the Department of Justice that you were the one who wanted this review, so that they felt like, well, it's not just these defense attorneys who we can blow off, it is a United States attorney who is asking for this review, and so therefore we need to give the courtesy of reviewing this? I don't think I asked for it as opposed to saying, if you would, so from the very beginning, they said that they're going to take this to the Deputy Attorney General and Attorney General. And I said, if you want to, fine. They just finally did, but that was not, I think they raised that as early as August or September. And so I'm not surprised that it ended up there. I also thought it was important to not be in the position of fearing review. I think if you look at the contemporaneous record, there's an effort on our part to expedite the review. By misredacted. I'm sorry. These two look so adorable. They actually behaved. They love their little spot. He's okay. He's a good girl. He's a good boy. Don't move because of me. Yeah, they love that bat. Okay, I think I'm going to keep that there. Okay, by misredacted. But there's a difference between have at it, go do what you want, up at Maine and getting that right, that non-opposition, and actually sending a signal to, in the case of the Criminal Division, the Assistant Attorney General, in the case of the DAG's office, Mark Phillip or his assignee, that you supported their review, that this appeal process. You could have said, look, we're going to go ahead and get on with our business. If they want to, you could have not so much opposed a review, but not seconded their request for the defense request for reviews, or not in fact invited the reviews. So I'd be curious as to the timeline. I would take issue with, I invited the reviews, and I question whether did they initiate the reviews on their own, and then I said, have at it, or did I, based on, you've got more of a record than I do, or did I invite, I would say I did not invite the reviews. Well, bad terminology perhaps. Let me ask you this, did you convey to the Criminal Division that you wanted them to review this matter, as requested by the defense attorneys? So from my perspective, I'm thinking back 12 years now. The very reason that we invited Redacted to come down to Miami back in August was a sense that it would end up here. And so if it's going to end up here, let's bring Redacted down. Let's make him part of the initial meeting. If there are concerns, let's raise these. Let's address them. Let's get them out so that we don't end up, after we go forward with all of this, back in front of Redacted and Redacted. And it's much better to involve main justice earlier. And so I would say I was trying, if anything, to involve main justice so that we didn't end up where we were, and it had been my expectation that that October date would have been met. The collateral reviews afterwards, the collateral appeals, obviously did not go as we planned, and it was my sense we were going to end up at main justice one way or another. So my question is, in December, after the December meeting, right, that you had with Defense Counsel, and they told you they were going to go to main justice, correct? To the criminal division, did you convey to main justice criminal division that you wanted them to conduct the review that Defense Counsel was seeking? So I don't recall what I may or may not have conveyed. I think my recollection was, if they want a review, that's their right. As a department, we're not in the business of telling individuals that they can't take something to your superior, or to your supervisor or your superior. Whether main justice takes this on or not is ultimately at their discretion. Would it surprise you to learn that the criminal division front office understood you to be requesting their review, the review that was sought by Defense Counsel? Would it surprise me? Perhaps. My understanding, recollection is we shouldn't fear it. If they want it, that's their right. I thought by inviting Redacted down in the first place that we had at least tried to address that early on, but I also thought that we might end up there in the first place. Were you aware that a decision was made to grant the decision by your office to grant Defense Counsel's request? Their insistence that Redacted's role in the criminal division review be limited to review only, and that he not be permitted to, or that the criminal divisions, I misspoke. That because Redacted had already been involved in essentially being a prosecutor on the case, right, that the criminal division and CEO's role vis-a-vis this review should be review only. That is, they should be taken off the case as a partner? So I sought emails to that effect in the record. I don't have an independent recollection, 12 years. 12. Do you think you were involved in that decision? To take them off? Yes. To my recollection, I wanted them on as a partner, and I think the contemporaneous emails from Redacted is, can you please come on board? But that was earlier, before this review process? No, even after the... Alright. Review process. I think there are contemporaneous emails where we're saying it's important that you be part. If you go to trial, it's important that you be part of the trial. As I went through the record, at least I remember, an email, perhaps from Redacted to Redacted that I'm copied on, saying, hey, can you reconsider? It's important that you be part of this. Reconsider the review-only limitation. No, reconsider being a part of the trial. Oh, alright, team. Alright, so to be clear, do I understand that you... Correct me, that you don't have a recollection one way or the other, whether you requested the criminal division to conduct the review, or it could have happened, or... So, what? To the extent Again, I'm going back. 12 years. To the extent there is a request to... It will be in the context of, this is going to Washington, we're not fearful of this, have at it. And you would have conveyed that to Washington, not just to the defense attorneys, is that correct? I imagine in some way it's... Alright. By misredacted. And just one? Yeah. Just one point. This one. This one was a little bit of a... odd posture. However, because you had a signed agreement, and so, basically a contract between parties, right, and particularly on Mr. Epstein's side, a party who was extremely well represented. So, was there any consideration on your part, instead of saying, hey, everybody's got a right to review, knock yourself out, go up to Washington, as opposed to saying something like, that ship has sailed, guys, you signed this agreement, we're going forward. You don't go forward, you're in breach, end of story. So, his counsel are raising serious issues that go to ethics and go to fundamental relationships between sovereigns. Is this 22.55 appropriate as a matter of federal policy? Is what we're doing an overreach? Is what we're doing contrary to law? Are we extracting? I'm characterizing. This may or may not be accurate. Are we extracting unduly? Are we using criminal law to extract civil concessions in an ethically suspect way? Those are serious issues. That isn't just, is this a good case? Those are genuine issues. I happen to think that, as I recall, that we were in the riot or we wouldn't have agreed to it. But by the same token, let's assume that main justice ultimately disagreed. Is that from a main justice perspective? And maybe I'm coming at this from a, being informed by having been at main justice. Where there was talk about, can you believe what this author may have done or may not have done without consulting? That these are serious issues. They establish precedent. They Maybe the DAG would have said, this is not the kind of thing we'd support, and this is wrong. And so at the end of the day, let's move forward. But once these issues are raised, I don't think a US attorney should say main justice should not review this. I think we're part of one department, and these are valid issues. Main justice doesn't need to take months to review this. Main justice can expedite their review, but those are valid issues for the deputy and the AAG to review. But one could look at it and say, well, those are all issues that the defence certainly knew about before they signed that agreement, and having signed the agreement, they are waiving all of that. That's what contracts are for. You've got all these issues, don't sign the contract. And if I could, I think there's a December letter. I don't know if it's in the exhibits, but there's a December letter that I wrote that, for me, this is the 19th. Maybe it's the 19th, misredacted. The 19th is your sort of ill-fated MPA addendum effort. The witness. No, a letter to Ken Starr that I wrote, but misredacted. The 4th letter is to Ken Starr. The witness. I'm sorry? Misredacted. Is it the December 4th letter? The witness. Yeah, it's probably misredacted. December 4th. The witness. Is the December 4th? Misredacted. Yeah, it didn't have a date. Misredacted. All right. That's the one you wrote. The witness. So, misredacted. To him? The witness. So, misredacted. In response to the witness. So, misredacted. 22.55 issue. The witness. I think, I'm starting on page 4. I have responded personally in some detail to your concerns because I care deeply about both the law and the integrity of this office. I have responded personally and in detail as well because your letter troubled me on a number of levels. Upon your understanding of the negotiations the 22.55 was first discussed July 31st. And one of these 4 points in the middle of 2007, your defense team asked to meet with me. On December 7th, I met. After considering of the arguments and after conferring with the FBI and redacted, our office decided to proceed with the indictment. At that time, I offered to delay our prosecutors to delay presentation to allow you to appeal our decision if you choose. You chose not to. Instead, you elected to enter into the MPA. Since the signing of this agreement, the feds in our office have addressed several issues that have arisen, although the exchanges at the time were a bit litigious. By misredacted. Could I point out, that this letter is in response to not the request for a review by the criminal division. That comes later. This is in response to Ken Starr's letter to redacted about raising 22.55. 22.55 issues that had been raised with you before. That had not been raised with you before, sorry. Right, which is in essence a review. I mean, they're coming to main justice, and it's against these many previous foregone opportunities to object that I received with surprise your letter requesting an 11th hour after the fact review of our agreement. Although it happens rarely, I don't mind this office's decision being appealed to Washington, and have previously directed our prosecutors to delay. Indeed, I am confident in our prosecutors' evidence and legal analysis. I nonetheless directed them to consult with subject matter experts in the criminal CEO's division to confer to our interpretation of the law before proceeding with this indictment. So I guess, we consulted CEOs. I'm thus surprised to read a letter addressed to the department headquarters that raises issues that either have not been raised with this office previously or have been raised and in fact resolved in your client's favour. I'm troubled likewise by the apparent lack of finality in this agreement. The authors have been negotiating with defence counsel and have for some times complained to me regarding the tactics used by the defence team. It appears to them that as soon as resolution is reached on one issue, defence counsel finds ways to challenge the resolution collaterally. So this is your protest of, it sounds like Starr's effort to bypass you and go to redacted with new issues. It is, and I'm pushing back in that. Was I inviting this, or was I sort of saying, that said, there must be some closure on this matter? Some in our office are deeply concerned that defence counsel will continue to mount collateral challenges to provisions of this agreement, even after Mr. Epstein has entered his guilty plea and thus rendered the agreement difficult, if not impossible to unwind. In closing, I ask that you consult with co-counsel. If after consultation with your defence team you believe that our agreement is unethical, unlawful, or unconstitutional, I'd ask us that you notify us immediately so we can discuss the matter by phone or in person. I have consulted the chief prosecutor in this case, who has advised me that she's ready to unwind the agreement and proceed to trial if necessary, or appropriate. So, are you suggesting that this represents your protest of their appeal to redacted? So, on this point? So, protest is a loaded word. What I'm suggesting is, this is not an invitation to appeal to main justice. That is sort of saying enough is enough. But, Mr. Acosta, in fairness, to clarify, right, this is in response to a letter directed to redacted dated November 28th. Right. 2007, raising issues that he had not raised with you. The appeal subsequently that I was asking about was, right, an appeal for a de novo review. A de novo review of the whole case. Understood. And the reason that I read this, is not, on the one hand, I'm saying we do not fear review, but this is not an invitation to defense counsel to do a de novo. I am not inviting them. I'm not saying, let's have more review. I'm saying enough's enough. If they appeal, that's fine, but this is not an invitation to appeal. But there was nothing you could do to stop their appeal, right? Except indict? And so the department shouldn't stop an appeal to main justice by threatening, fair enough, because main justice has a right to review. I should have said that this appeal process was stymieing progress in resolving the Epstein case. It was. And you had no recourse other than, at least theoretically, you could have just said, we're, right, going to tear it up and indict because you're in breach, in effect, which would have raised civil litigation, overlays, which is the point that I thought merited, alright, at least flushing out. By misredacted. So, short of the department itself getting a move on and getting this thing through expeditiously, did you feel like you just had to sit there and wait for everything to get done? I'm not sure sit there and wait, but ultimately the case did not get better with time, and there was frustration on our part about, the witnesses are not getting better. Time, they're getting older. Which goes back to how a juror may see them. Misredacted. Right. The witness. And I do recall conversations of they're getting older. This case is not getting better. We now have the civil overlay that we need to deal with. And so, yes, there was process. But while there was, should we just call it a day? All of that factored into, well, if the department is reviewing, the department is reviewing. By misredacted. Okay. What is your view of whether the criminal division's review encompassed the MPA itself? So, the criminal division, by its terms, did not encompass the MPA. I would say that's different from the deputy's review that encompassed the totality of the circumstances. Okay. Did you have conversations with the DAG, with Mark Philippe, about this case? Not to my recollection. Okay. And we've already talked about the submission that Redacted made on behalf of your office, which I thought was a fulsome submission, and included the draft indictment, the MPA. I believe it included the term sheet and other documents. Did you or anyone else to your knowledge ask ODAG to review or assess the MPA, or approve it? Before signature, not to my recollection, but it was part of the ultimate review when Redacted submitted the matter to the deputy. He included the agreement. It was included. Their very brief letter, you remember? The letter that redacted? Yes. Authorized? That he offered? Sorry, offered, not authorized. Offered, that he offered. Addressed really only the issue of the appropriateness of the case for prosecution in your office. It did not in any way reference the disposition, the plea agreement, or the MPA. So it was a brief letter. Based on Redacted's submission, I would have read that letter as they had all the material in front of them, and they were saying that there was no misconduct or abuse of discretion. That's correct, but they did not say that they contacted, that they addressed or assessed, reviewed even. They didn't say they reviewed or approved the MPA. If the letter is here, I don't know, but yeah, I have it right here. It's not marked as an exhibit, but this is Redacted's letter to J. Lefkowitz and Ken Starr, dated, June 23rd, 2008. It states that this office, meaning the Office of the Deputy Attorney General, has completed a thorough review of the U.S. Attorney's handling of the matter involving your client, and states that they've received and reviewed submissions from both parties, and then states that the Deputy Attorney General will intervene only in the most unusual of circumstances in a U.S. Attorney's matter, and we do not believe such intervention is warranted here. Even if we were to substitute our judgment for that of the U.S. Attorney, we believe that federal prosecution of this case is appropriate. Moreover, having reviewed your allegations of prosecutorial misconduct, and the facts underlying them, we see nothing in the conduct of the U.S. Attorney's Office that gives us any reason to alter, our opinion. And so if I could point out, this office has completed a thorough review of the U.S. Attorney's handling of the matter. And so, handling is a broad term, and in reference to, we believe that federal prosecution of this case is appropriate. The way I recall reading that is, the federal prosecution of this case, the argument was that the agreement was inappropriate because this case should not have been even prosecuted, and therefore that the disposition, the federal prosecution of this case was appropriate. And so, the handling of the matter, we reviewed the handling of the matter, not the agreement, but the handling of the matter, and that the ultimate disposition, if, is at least not an abuse of discretion, or is appropriate. And that's how you read it? That is how I read it. And did you ever discuss that? Did you ever discuss with anyone in ODAC what the scope of their review was? Not to my recollection. It was a fulsome submission. Correct. But if the issues presented by the defense were essentially federalism issues, right? So again, this is based on, as much recollection as contemporaneous record. The issues presented by the defense were, in essence, it was the heart of the non-prosecution agreement, which is, was it an abuse of discretion to proceed in this case in the way that we did on the grounds that there should not have been a federal prosecution in the first place, or that we were using federal criminal law to elicit a civil outcome? And so I don't think it's fair to sort of narrow. You can't say that our handling was, that their handling was reviewed without reviewing the non-prosecution agreement. Do you have any reason to believe that either ODAC or the criminal division that the ODAC, let's stick with that, right, did in fact review the MPA other than to be aware it existed, whatever its status might have been? So again, it was clearly submitted. It was clearly referenced. And it was clearly part of the complaint. The heart of the complaint about our office was that we were using this agreement to impose civil liability. And so I think it is fair to infer if the complaint implicates the agreement, that the agreement would have been reviewed. But that's your inference. You didn't have any specific communications with ODAC. To that effect, I don't recall a specific communication. Alright, okay. I would like to take a short break. We're getting there. I hear you. There is, all good, one area that my colleague, Redacted, will take on, which has to do with the CVRA. Right. And then we have some kind of wind-up questions. Okay. Mr. Redacted, before we take a break, can I just... Mr. Redacted, yes. Mr. Redacted, I'll try to queue up what's going to be coming next. The witness, Mr. Redacted, and maybe that'll help us move through it, because... The witness, right. Mr. Redacted, you have been through a very long day. The witness, yeah. Mr. Redacted, we appreciate the time you put into this. You've been here for quite a long time. The witness, well, yeah. By Mr. Redacted. The area that I want to discuss after the break has to do with the ultimate notification to the victims about the resolution of the case, the state plea, and the result of the federal investigation. And there's going to be... We have documents that are that are already marked there that might be helpful if you take a look at a couple of them, so we don't have to go through... Maybe during the break, so we don't have to go through them one by one. Or I can just give you a very quick overview of where we're going. I want to find out basically how you were getting from there. What would be the state asking for the US Attorney's Office to make the notification to the victims about the upcoming state plea that happened in November of 2007. There will be document 32B to the defense, then finding out that the government wants to notify the victims by letter, and then demanding that they see the letter and have some kind of comment on it. There will be document 33, an email from Lekowitz. Then we have an exchange of letters, but the one I'd like you to look at is document 37, which is a letter coming from Redacted to the defense. Not now, but, during the break. So I want to find out how we get from that document, 36, where Redacted is writing, Miss Redacted, 36, by Miss Redacted. As letter saying that, citing the CVRA regulations, saying that the government is obligated to notify the victims about the resolution of the case, and attaching a draft letter to the victims telling him the time and date of the state resolution and plea, inviting them to come. To ultimately a letter from you coming on the 19th of December 2007, which is number 41B, agreeing to not notify the victims of the state plea, and agreeing with the defense to have the state be responsible for putting out that notification. And then we end ultimately with a letter or draft letter that we have that goes out to the victims in the case on after the plea in July. Well, we have the draft I'm going to show you, which comes in June, showing that the letter was clearly meant to be sent after the plea as per the agreement, and that is document number 51. Okay, so it was a lot to... unpack there. That's a lot to unpack. We should probably take it a step at a time? Yes, I just wanted to. Alright. Give you an overview, because I think there's some of what you had mentioned earlier, and I know it's, been a long time, so, I'll try to orient you for the timelines. So, if you just have I've highlighted the sections of those letters that we want to talk about, and if you have a chance while we're taking a break to look through them, that may help orient you so that we're not, spinning our wheels on this. I don't want to waste any of your time. Fair. Miss Redacted. Alright, off the record. Off the record. Speaking of break, I need it. Oh, you're okay, Clara. You're right. The water bottle was right beside you. There's a good girl. Oh, they look so comfortable. And what's better is they're not causing any mischief. Oh dear. Sorry, my throat's a little dry. Not that whiskey will help too much, of course, but it'll help numb it a little bit. Ms. Redacted. All right, back on the record. Mr. Redacted. Are we back on the record? Ms. Redacted. Yes. By Mr. Redacted. Okay, great. So I know I gave you a lot to unpack of the short break we just had. One, basically what we're trying to get to find out is how your decision-making process regarding the victim notification issue. So maybe if you could just give us anything with your December 19th decision, could you give us an explanation about how you got there? So I think we should probably take this in stages. Okay. As a general matter, I recall that there was back and forth after the agreement regarding how to notify the victims, and there was back and forth between Redacted and Jay Lefkowitz and Redacted around all that. Sorry, I'm losing my voice. So am I, but that's okay. And I recall that there was an issue in particular that was raised that I tried to address in the letter, and I recall at the end of the day, it was my impression that once there was an agreement for him to plead, that there was an attempt by Redacted to provide notice to the victims, but it was I think I was on a Friday, and he was pleading on a Monday morning or something along those lines. And finally, I recall that the view of the office was that the CVRA did not apply, and so that this was a discretionary balancing that included consideration of what impact notification of the 22.55s would have at trial, the 22.55 provision, if we had to go to trial. He's a good girl, Clara. So we can unpack that, but those are my general recollections. Okay. And look, let me add, I think it's important. So I came in and out of that case at stages. Sorry, cat's lying, spread eagle wanting a belly rub. He's a good girl. Yeah, Clara's very rarely like that these days. Dexter definitely is, but I think Clara is very, very comfortable right now. So I came in and out of the case at stages, and I was involved in certain aspects more than others, and while we had a long discussion about the term sheet and matters like that, while I was clearly involved in at least one dispute around the 22.55, the nuts and bolts of how victims were notified is not something that I have a recollection about. Okay, fair. But we can unpack it. Okay, let's start with the Exhibit 33. So there, we have as you can see, it's an email from Lefkowitz. To you, and to Redacted, objecting to a letter being sent to the victims unless the defense gets to review it. And later on in some of your other correspondence, you discussed that you extended to the defense the courtesy of allowing them to review these letters. Is this the genesis of that courtesy? I don't have a recollection as to what the genesis might be. I know that there was back and forth between our office and the defense about that letter. Okay, but as you can see on 33 that you're not in the response from Redacted, but Redacted instructs Redacted to send the proposed letter to Lefkowitz, and yeah. I assume that Redacted wouldn't have done that had you objected to it. Again, I don't recall any specific conversation. As a general matter, this is not something I was getting into the weeds on unless I had to. There was a lot of back and forth. Redacted is someone that I trusted. He was handling this matter. He's incredibly experienced. I know that there were concerns and issues around the impact that notification would have on the witnesses. I know there were issues around the language, and I trusted that folks were working these out. One of the criticisms that's come post, the CVRA, right, litigation, there's been the government allowing the defense to have review of those letters, or potential victim notification letters coming out of the government, and that's unusual. Have you had any other cases where you've let the defense review such documents? I've had no other cases where I'm even aware of victims being notified, because I assume it all operates without it rising to management level. And so this is the first and only time that how individuals are notified, to my recollection, was even in the executive suite. Isn't that usually done, accomplished by almost a computerized task? I would assume so yes. And given that that's the usual way that notifications are made by a victim witness specialist, who is usually that person? Yes. Do I have that right? And so the FBI has their victim witness specialist? Yes. And your office, the U.S. Attorney's Office, has dedicated people to do that job as well? Correct. So why, in this case, not direct, this notification to that person to be done in the usual course, why elevate to something that the defense is going to be able to review? So I can't address the second half of that, but the first half of that question, why? Why was it elevated? I think Redacted addressed some of that in her, was it 2017 affidavit? And And so we had an agreement that had been signed, and we also had substantial questions as to whether ultimately Jeffrey Epstein would plead in court or not. And so one of the questions is, how do you deal with notification of a possibility where that possibility could be used to impeach potential future witnesses who are also the victims? And that is a matter that was being worked out by the authors in the office. And the impeachment is what? And so the impeachment, and I believe Redacted went into it in some detail, is you, Miss Victim, stand to gain quite a bit of money if there's a conviction, correct? When you're aware of this agreement, hey, guys, calm down. And this isn't based on my recollection. This is based on the redacted affidavit, where she says that she had concerns that the impeachment go along, somewhere along the lines of, were you aware that if Mr. Epstein is convicted, you stand to receive substantial sums? Yes. Were you influenced by this? And there was some, according to her affidavit, this isn't my independent recollection, this is according to her affidavit, there had already been dispositions of the victims, of at least some of the victims that raised these issues. And so I do think it was a valid concern by the authors how these notifications took place. Okay, but isn't that type of line of cross-examination the same for any case where there's a super wealthy defendant? It may be. The 22.55 may make it a little different because it's automatic. But ultimately, there are the judgments that line attorneys make, and as US attorney, I think it's appropriate to back up their judgment unless there was some reason for me to believe it was incorrect. Was there any thought ever to just giving the victims notification that there will be a proceeding that will end the federal case, just separating that in maybe a later notification about the 22.55? I can't speak to what thought there was or was not. I can say around this time frame it was far from clear that Epstein would ever go into court, and we were thinking we may have to just go to trial, because these collateral attacks keep going. Okay. Let's get back on track to the question that I asked earlier about allowing the defense the courtesy to look at these letters is, can you just remind us again, what was the reasoning that they're allowed to look at the victim notification letters? I can't speak to that. This is something that Redacted would have handled. I think that, I'm responsible for the office. I'm not shirking. I'm just saying that this was for the most part within their wheelhouse, and not something that I was involved in. I can speculate. Sure. The agreement was notifying them. The letter was notifying them of certain rights in the agreement, and therefore this is a time where we weren't sure what was happening with the agreement. And so perhaps this is a way to address some of the concerns around the 22.55. I don't know. I'm just speculating. Okay, let's move on to Exhibit 36. This is a letter that goes out to Lefkowitz under Redacted signature. You are CC'd on the letter. Alright. And what he is doing is sending a draft victim notification letter, which is attached as the attachment there, dated December 6, 2007. And I wanted to get your impressions of... If you go to page 3 of the letter, please. And the first little paragraph there, when it refers to the Victims' Rights and Restitution Act, and then ultimate for the CVRA. If you could just read that paragraph to yourself, please. Are you referring to paragraph 10? I'm sorry, I'm on the letter, not... I'm sorry, I'm on the... Oh, left. The letter to... Sorry, Lefkowitz, not the draft letter. This one right here. The additionally? Yes, additionally. Pursuant to the Victims' Right and Restitution Act of 1990, our office is obliged, our office is obligated, etc. Okay. Do you agree with that language? That interpretation of the victim's rights as far as the notification? So let's sort of take this one sentence at a time. With respect to notification or other information that we were supposed to disclose, the statute requires that we provide victims with the earliest possible notice of... I would assume that is a restatement of the statute. I don't have it in front of me, but let's assume that that's a restatement of the statute. Just as in 18, these sections are not limited to the victims. Through this federal... should be appropriately informed that a non-pros does not require to forgo his legal obligation. On a sentence-by-sentence basis, do I agree, sitting here? Sure. But I would want to sort of sit down before I gave a legal opinion and spend more time with it, but... Okay, because coming out of your office, sort of this and that... Well, let's go to the next page, page 4. Yeah. There is a citation to the right to confer in the first paragraph there, citing the CVRA's reasonable right to confer with the attorneys of the government in this case. Okay, so we have, it looks like to me, right. Well, it appears that there is 2 references to the CVRA obligations that ultimately the government argues that it did not have. Can you explain why that is a correct interpretation? So, what I can say is, I recall So it looks like at least some of the victims were notified. I recall a discussion and a view that the CVRA did not require it. It was discretionary. Because it wasn't, the case is not indicted. Indicted, so it did not attach on its terms. That doesn't mean that it's not something you aspire to. That just means it wasn't legally binding. So, and in the same manner though, while the CVRA isn't legally binding, it also doesn't prevent you from notifying the victims, does it? It does not, no. And you have the discretion to notify should you choose to. Correct. Okay. And so, if you look at the letter that's attached to this is a draft that goes out, we're on page 1, 2, and page 3 of the letter. And the second to last paragraph, the letter is giving notice of Mr. Epstein's change of plea and sentencing that will occur on, well, at this time it was December 14th of 2007, and it gives the address, and it says underneath, there, you are entitled to be present and make a statement under oath. If you choose, you can submit a written statement under oath, etc., etc. So this is a letter that's actively inviting victims to come to the state. Would you agree that that's inviting victims to come to the state plea? I think that's fair. And with the letter's reasoning that the government is sending, would like to send this letter because it believes it's obligated to, because it resolves the federal case. So I don't want to speak to the reasoning, but it's clearly a draft that the government is saying it intends to send. Okay, now ultimately, this is not a question, just got it. Some information that will help to move us along. Right, obviously this letter is never sent. Misredacted drafts, we have them, and I'm not going to show them to you, 30 letters, copies of the letter. Right. To different victims. Addresses them, puts them in envelopes, and is then told not to send the letters. Alright. Well, the plea is scheduled for December 14th, so yeah. Yes, but one of the issues that's still percolating until the end of December is who is going to make this notification, because as you can expect, the defense pushes back on this letter. And so now we go to the number 39, please. And this is... oh no, wrong voice. And so now we go to the number 39, please. And this is a December 11th, 2007 letter from Ken Starr to you. And if you look on page 2 at the front, at the top of the page there, this letter is complaining about an oral notification that Misredacted gave to one of the defense, one of the victim's attorneys, that a letter would be coming. And so Mr. Starr is writing you to complain about it, and he mentions it later in that paragraph, that we have thought that the notification process had been in abeyance until completion of our ongoing discussions with respect to that process. So were you having discussions with Mr. Starr about the process at this time? I don't recall discussions. I think there was at least correspondence, or... I'm sorry, where are you? I was reading the letter. I'm sorry, where are you? What paragraph? Let's take a look. And it's been a long day. Let's slow down here. We're on the second page of the Starr letter. Right. Oh no, yes. And it would be this and that, the language in there, in the second sentence which goes towards the bottom. This notification, but quite apart from our substantive concerns, which we have thought the notification process had been in abeyance until the completion. That appears not to be so. This is respectfully... So, where does it imply that I was having... I don't recall communications with Mr. Starr. That's why I'm curious where... At least verbal communications. I'm curious where you're reading that from. I thought he's saying we had thought that the notification process had been held in abeyance until completion of our ongoing discussions. Are you saying that he's... So I don't know where that may have come from, but I don't recall. I recall at one point, I think I sent a letter saying we'll hold off for a week. I don't recall the date of that letter while you review some matters. Where the abeyance comes from, I can't speak to. Okay, let's go to Exhibit 41B. This is your December 19th letter, and what I'd like to draw your attention to is page 2, the second to last paragraph there. Yes. So, could you tell us how your decision-making around this paragraph? How you got to this decision? Oh. So you're asking me to recreate. At some point, the issue clearly moved from redacted interacting with defense counsel to my desk, and my recollection 12 years after the fact is... So you're saying we shouldn't notify them about the state proceeding, and sure, the state. This was negotiated between Epstein and the state attorney. We did not direct the state proceeding, so whatever state process is appropriate for the state process will be given. But with respect to the federal resolution, we intend to provide victims with notice of the federal resolution as required by law, and your question is if we thought it was discretionary. Let me just bring up something on my end. I recall believing it was discretionary, but you could also... It doesn't hurt to in a letter say we're kind of required to do this, and I think it was the right thing to provide them notice of the federal resolution. And once that resolution was reached, and part of the key word is what the resolution is, my... let me just bring it up. There we are. So I'm just checking the rest of the files in dataset 7. I want to know sort of how many files we got after we do this this whole thing. Because I suspect... Well, I could end it. I could make this a short stream and end it here, but I want to sort of balance it out and give myself, a decent amount of stuff to do next stream. But also, it'll be to end and finish dataset 7. Anyway, yeah, and once that resolution was reached, and part of the key word is what the resolution is, my understanding is that Redacted made efforts to notify victims of that resolution and let them know that there will be a hearing the following Monday that they should attend because it would bring an end to the case. Well, let's just back up real quick. As far as the state attorney notifying people of victims of the state resolution, did you have any concerns with that particular part of it? So, difficult to recreate the thought process 12 years later, but ultimately you've got federal, and you've got state, and the state attorney will do what the state attorney thinks is appropriate. It's not for me to direct the state attorney. I'm inferring, based on this language, it's not for me to direct the state attorney, or for our office to direct the state attorney's office on its obligations with respect to the state outcome. Okay, I'm just asking because, the whole case came to your office because of some issues with the state attorney's resolution of the case. So now it's going back, and they're going to be in charge of the notification. Did that raise any flags with you, or did you have any concern about whether it would be done correctly, or done at all? So again, this has come up in different contexts, and I think there was obviously a concern about how it was being charged, but that doesn't mean that they will not fulfill whatever obligations they have. Let's not assume that the state attorney's office is full of bad actors. Okay. By misredacted. But even if not assuming that they're full of bad actors, it's going to be difficult for them to notify the victims, wasn't it? That they didn't even necessarily know the same list as the federal victims because you had found more victims. So we could certainly have shared that list with them. I mean, there are ways that this could have happened. I don't know what the communication were, but as a conceptual matter, having the state notify them of the state hearing and having the federal government say, and this is the federal resolution, is consistent with the law. But since whose voice is it? Ah, yes, it is her. But since the federal resolution is tied to the state plea, why not just combine the two of them in the notification? Here's the federal resolution. We're tying it to the state plea, and here's... The date of the state plea. I can't speak to the why not. I can speak to my belief that this would be consistent with law. That could also be one approach. I can't speak to why A versus B. Did somebody instruct you that... Or did you have a conversation consulting with somebody about whether this was the better approach? I would have said, based on practice, not recollection, but based on practice, I would have sat down with Redacted, most likely, since he was handling this matter, and we would have talked about it. I would not have sent this without running it by at least Redacted, if not other individuals in the office. I don't know if based on your record there's emails with drafts, but... every document that I'm aware of was sort of shared within the management team, and this would have been one of those. With respect to that one specific decision about this, should be at the discretion of the state attorney, did you consult with anybody in DC about that issue? I don't recall consulting with someone in DC about this issue. I recall a general perspective that the CVRA as a technical matter did not attach because ultimately this was not an indictment. By Mr. Redacted. Oh, can we... Before we leave this letter... If I could, and I understand your questions, but I feel some obligation to raise the tension between did you consult in DC versus should you allow DC review. And so just, we certainly were allowing review, but US attorneys' offices don't consult in every matter, especially offices that have the kind of experience... Mr. Redacted. The witness. That Miami does. Mr. Redacted. Back to me. Mr. Redacted. Mr. Redacted. Mr. Redacted. Back to you. By Mr. Redacted. Before we finish with this letter from the 19th, can we look at page 3, please? If you could read the first paragraph on page 3 to yourself, please. Okay. Could you, in that section, you mentioned that prosecutors had asked you to declare a breach, and you resisted. Can you discuss this? So, sure, that's referencing I think, increasing frustrations by the prosecutors, and I think that's reflected in contemporaneous emails saying, why don't we just rip this up? And I recall conversations with Redacted, and that goes a little bit to what we talked about earlier, which is concern that a unilateral breach would overlay not just the initial issues that we had, and not just the fact that the victims are getting older, and the cases are getting better. But then we have, was the unilateral breach a valid breach, or was it not a valid breach? And is the delay justified or not justified? And ultimately, that additional liability, that additional legal uncertainty would have made the case even harder because they were very careful to always say there is no breach. Misredacted. The witness. Let me address, because I went on to read the next paragraph as well, and so let me circle back to an earlier issue. Misredacted. Great. The witness. Because I at least want to address it, because the next paragraph then says, and it's clear that I'm increasingly frustrated. It's against that my frustration with it appears to be an 11th hour appeal weeks before the now scheduled July 4th plea date. That said, the issues raised are important and must be fully vetted, irrespective of timeline's concerns. We hope to preserve the July 4th date. I understand defense counsel shares our... With this in mind, and in the event the defense counsel may wish to seek review of our determination in Washington, I spoke this past Monday with Attorney Jen Redacted, confirming if it's possible, appearing to ask her to grant the potential request for review, and to in fact review this case in an expedited manner in an attempt to preserve the July 4th date. Mr. Redacted, July 4th. Mr. Redacted, that address, January. The witness, I'm sorry, the January 4th plea date. Sorry, it's by Mr. Redacted. And that addresses the question I was asking. And that goes to the question you're asking, and again, I'm recreating and I'm speculating. Having that following the another 11th hour appeal here, I would say I wouldn't say let's appeal this again. I think I'm saying pretty clearly it's against my frustration with what appears to be an 11th hour appeal weeks before the now scheduled January 4th plea date, that this is not an invitation to do another appeal, because the appeal is already in Washington. But my saying, if we're going to do this appeal, let's get it over and done with, then I'm sort of speculating based on the language, so that we can get this pled on January 4th, and let's not put it off until after the holidays. But you did say to ask her to grant the potential request, which is for review, which is why I wanted to, on my own, raise it, because is that saying please appeal me, or is that saying this is an 11th hour appeal that you have now taken to Washington? It is December 19th, we're about to go into the holidays. There's a January 4th plea date. There should not be another way to put it off. And so, if you're going to do this, I'm going to try to expedite it so we can get this done. I'm just going to look at the chat real quickly. Okay, I'm both here and going to the hardware store. Excellent. I'm glad you can listen. Finally caught another stream and I'm curious, are you reading an active of the files or the .gov version? I'm asking because the version on government websites started getting purged as soon as the war in Iran started. I downloaded all these files from the government website as soon as it appeared. So, last-minute redactions have not appeared so far. That said, I think Dataset 7 is the last one I've actually downloaded, so I'll have to download the rest. But what I've read up to this point is as unredacted as it's going to get. So I hope that helps, and yeah. As I say, I do understand the redactions for certain victim information. That absolutely has to be redacted, but, certain protected names, yeah, I'm a bit leery about that. Certainly, I think after Dataset 7, because I haven't got 8, 9, 10, 11, 12, I'm going to have to download those. But those are huge files, so yeah, my PC couldn't take it. But no, this initial early stuff, that is fully the most unredacted version I can get. I grabbed it immediately because I just knew they were going to try and wind it back. Okay, continuing on. And in fact, it took until May, 15th. And it did, and apologies, I just realised my voice is, alright, rising. So I don't know if that's my frustration at reading this again or it's getting late, but it was a frustrating matter. Apologies. By Ms. Redacted. Let's just move to Exhibit 46. So this is an email from Ms. Redacted to you and Redacted discussing how she has interviewed some victims that day. There's a mention that one of the victims said that she would rather not get any money, and she would rather have Epstein spend a significant time in jail. Did that piece of information go into your character list at all about how the case should be resolved? So again, not based on recollection, because this is maybe, if not 12, 11 years ago. Okay. But at this point, there had been an agreement. The agreement was signed. It was being reviewed. Based on this email, we're trying to get and expedite the criminal division because I see it says, please reach to Redacted to make her decision. And I think at this point, as I said, if we knew earlier If we knew that it was going to go this long and take all of this, I think we may have approached the case differently. But we were so far along in this, there was a signed agreement. The United States can't unwind an agreement just because it's frustrated, or just because some victim indicates that they don't like it. That's not, if the agreement is not legally valid, if there are some other concerns, but I don't think this in and of itself would have been grounds for unwinding an agreement. Do you think it's misleading for the government to have been interviewing those witnesses and preparing them for a trial when there's already a signed MPA that resolves the issue? So that was part of the judgment, that there's a signed agreement, but based on the course of conduct, is that agreement really an agreement that will be honoured? And so there was an ongoing investigation as well, because we didn't know if we go to trial. And my recollection is that the judgment was until we know that this agreement is really going to be performed fully, that to inform victims of the possibility of civil recovery is problematic, and I can't say that judgment's incorrect. That I think that's a valid judgment. Fair enough. And then the last question on this email is at the bottom. Ms. Redacted invites you to attend interviews with 4 of the girls who will be coming in the following day. Did you attend? I did not. And as U.S. Attorney, I don't think I attended. That wasn't typical for our office. Had you ever had that type of request come from a line assistant? Not my recollection, but I also tended not to have communications come from line assistants in the first place. Were you at all curious, you discussed the issues with the witnesses in this case, right? That potential impeachment and that went into the negotiation phase. Did you have any interest in seeing these people, even interacting with them personally, so you could make your own assessment? So, any interest is, would there be value in doing that? So, we had very experienced prosecutors. It's not just interacting with the victims were in a really hard position. It's not, how would I draw a distinction between a victim being interviewed by an agent and how a victim holds up in court, in a public setting under cross-examination, and in that? I don't think anyone in the office was questioning the pain or the suffering of the victims. I think that the issues were, how will they hold up in court, which are uniquely trial issues? Okay, then let's move on to, what was your understanding that the federal government was going to do as far as the notification about the resolution of the case? So my understanding was that once we believed that the case was going to be, that the plea was going to go forward, that we would notify the victims of the resolution and of the agreement and how it played out. Now, are you saying now you had agreed to not notify? Well, did you? I mean, one would read your December 12th, 19th letter as an agreement that the federal government is not going to notify the victims of the state plea. And that will end that part of the case. Is that correct? So I would pass my letter differently, and this is 12 years after the fact. So this isn't based on recollection, but on my reading and my understanding of the course of conduct in this case, sitting here now, my understanding was that our office was notified. Was it on a Friday afternoon? Yes. That he would be pleading on Monday, and that at that time, Redacted made efforts to notify victims that he would be pleading, and that would terminate the federal resolution of this matter, and that the victims should attend that hearing, which wasn't the state resolution of the case. It was the federal resolution. And so you're saying that the state plea was also the federal resolution of the case? Based on my understanding of what happened, that's how my recollection... Based on having reviewed the record, that's how I believed it proceeded. Although I think Redacted attempted to do so, couldn't reach some attorneys, and exercised best efforts to let them know, but did not get a hold of all of the victims. Over the weekend. Before we get too deep into that, let's just take a quick look at Exhibit 51. So this is an email forwarded to you from Redacted from January, June 25th, 2008. So that is 5 days prior to the plea in this case. Yes. Or the state court plea. And the attachment there, you'll notice, is a letter with a notification of identified victims, and the letter is written, would you disagree? That is written with, on June 30th, Epstein pled guilty. Do you see that? Yes. So, the inference. It appears to be that this letter was to be sent after the plea. I see that. I also, based on my review of the record, where I think I'm recalling the redacted affidavit, where she said that she made an attempt to notify the victims as soon as she was made aware that he will be pleading in state court. Well, what redacted says in affidavit, correct, I believe is that she made notification, and the police department, Chief Redacted's police department, made notifications. Is that correct? Does that ring a bell? Mr. Todd, do you have a copy of the affidavit so we can just look at it? Mr. Redacted, do you have Redacted's affidavit email? Mr. Redacted, it's right here, one copy. The witness, I'll hand it back. Mr. Redacted, almost done. The witness. So, relevant to this paragraph, 34, and then another paragraph, these and other attacks and efforts to avoid the MPA's terms, led the FBI investigative team, the office, and me to conclude that prosecution at trial remained a possibility, and we should prepare as such. This meant that the victim notification letters had to cease because 1. We no longer knew whether Epstein would perform under the MPA, and hence we did not know whether providing information about the MPA would be accurate, until we believed that Epstein, through his counsel, would attempt to use victim notification concerning the MPA to suggest that victims had been encouraged by the FBI or the office to overstate the victimization for monetary compensation. And then fast-forwarding, because you can read it on your own. On Friday, June 27th, at approximately 4:15, I received a copy of Epstein's proposed state plea agreement, and learned that Epstein's state court change of plea was scheduled for 8:30 a.m. on Monday. The Palm Beach Police Department and I attempted to notify the victims about the hearing in the short time available to us. I specifically called to Attorney Edwards to provide notice to his clients regarding the hearing. I believe it was during this I never told that the state charges involved other victims, and neither the state court charging instrument nor the factual pro-offer limited the procurement of prostitution charges to a specific cell. So that was what I was referring to. Again, I am basing this based on my review of the affidavit, and not on recollection of how this may or may not have been proceeded, or may not have proceeded 12 years ago. Okay. Would it surprise you to learn that Ms. Redacted only communicated with Mr. Edwards that day? That's because she was under the direction from a manager to only contact Edwards regarding this, the potential plea for that Monday. Hello, Dexter. The affidavit said she attempted to notify the victims, so I can't speak to that. Okay. And I don't have an independent recollection of this going back 12 years. Were you aware that Ms. Redacted was directed to have no communication with the state attorney's office, and probably during that latter period of the case in 2008? Not to my recollection. Okay, so would you not recall hearing anyone directing her to not communicate with the state attorney's office? I can't speak 12 years later, what role I may or may not have had. I question how, if there is an attempt to schedule a plea and all of that, how can there not be communication? But I can't say whether I did or did not. When I say I have no recollection, I mean that in the broadest sense of the word. Okay. In your December 19th letter, you did agree that the state attorney's office would notify the state's victims, right? Yes. And do you have any idea how that was to be accomplished? I can't speak to that, no. And would you have any knowledge of who the state victims are? I would infer that... No, Dexter, don't do this. That is not the place the cat should be. You've got a blanket here. Sit there. Don't sit by my mic. No. Move. No. That way. That way. There we go. Good boy. Sit there. You're a good boy. And would you have any knowledge of who the state victims are? I would infer that our office would have had sufficient communication with the state attorney's office to communicate who the victims were in this case, because it was an ongoing matter, but I don't know. Do you want to go on? Ms. Redacted. Okay. Are you done with that portion at least for the moment? Mr. Redacted. Yes, thank you. By Ms. Redacted. I just want to clarify something you said a moment. Sure. Ago, Mr. Acosta. You said you referred to the agreement, the MPA, as having been... It was signed and was being reviewed. Were you talking about Washington? Right. The criminal division. But we established earlier, did we not, that the MPA was not the subject of the criminal division review. They expressly declined to review it. I stand corrected. Okay. I just wanted to be clear on the record. Thank you. So we've had a lot of conversation about facts. We are fortunate in this case to have a plethora of documents upon which we can rely even 12 years or so after the fact, and we've tried to plumb the depths of your memory as to the events. Are there any facts, any conversations, any incidents, anything based on the questions that you've heard here today that you have recalled, that you want to tell us about, want us to know? So give me a minute to just sort of think this through. Of course. I think we've covered most of the issues pretty clearly. I guess I would have two general comments. The first is whether folks agree or disagree with the initial 2 years, registration and restitution. The office's focus was on having Mr. Epstein go to jail at a time when, from our perspective, these cases were, at least presented with these facts, federally at least unusual, and that most trafficking cases involve a different sort of nexus. It involved bringing individuals into the country, or holding individuals against their will, or doing something like that, and this will go to my second point, which is, sitting here, we now see several high-profile individuals who abuse power and have now been prosecuted, who were known at the time who abused drugs, like Bill Cosby, and there were rumors at the time, and so looking back, maybe it was the right call. Maybe it wasn't the right call, but there is some degree of... I'm not sure what the right objective is. Frustration. That, and certainly some of this goes to me. But I think a lot of this goes to Redacted and the individuals involved, that the attempt to put someone in jail, as opposed to decline the case and say this is just a state case, that the federal issues are too tricky, that ultimately this is sort of novel interpretations, that the attempt to come up with an outcome has rebounded in the way that it has, and I'm not saying, look, that's life, but I understand that. Sorry, I'm stuttering a bit. But I do think it's important to look back on this and try to be in the shoes of the thought process in 2006 and 2007, when trafficking prosecutions were fairly new, when, more so than today, some jurors may have looked at this as prostitution and were, perhaps more so than today, judges' tolerance for victim shaming may have both caused more hesitation on the part of victims, but also created more issues at trial. And so I think we touched on that, but I think as we sort of wrap up, this portion of it, it's important to just restate that. And to, in addition, are there any facts conversations or anything that you did ask this, that we've not really elicited from you that you want us to know? And to be clear, you'll have an opportunity to, supplement this. Not that I can think of. Alright, sitting here. Alright, how do you respond to public criticism that the defense attorneys, the Epstein defense team, were gaining extraordinary access to an influence on prosecutors from the line level all the way up through the department? So I will point out early on in the case, when I said early, you push back, but from my perspective, early on in the case, not when it was first investigated, but when it first bubbled up for decision. And that would be mid-2007, June-ish, May to June 2007, May, June, July. We determined, here's what we need for resolution. And I think I addressed some of this in the Daily Beast letter. Because we were receiving criticism back then, and I think that letter has been misconstrued to some extent, because it was not, here are some influential people, we're backing off. It was, we early on set 3 criteria. 2 years, registration, restitution. Despite all these attorneys, despite all of these appeals, despite all these efforts, the office did not budge with the caveat of the 24 to 18 months, which we've discussed, and from my perspective, despite all of that, I backed the office in sticking by that resolution in the various appeals to Washington. And so ultimately, it was a year-long process, but we ended up a year later exactly where we started, with the caveat of the 24 to 18. And so, to the extent that there was influence, there was no change in position. Well, my question was access, that this team of defense attorneys, had extraordinary access, that they asked for meetings, they, pressed for, with communications, and they had that access. Did that seem extraordinary to you? So they asked for a meeting with me before the agreement was signed. I granted that. That's not the first and only time that I granted a meeting to defense attorneys. I don't think it's atypical, particularly as a case is coming to resolution, for a US attorney to sit down and meet with opposing counsel. And I can think of several cases where that happened. There was certainly a lot of access in Washington. I would speak to, I think that's a question to direct to this building. Because the process here was lengthy and frustrating. But I think we successfully held firm in our positions, despite all the process in this building. And again, my focus is not on your response, but on the access. And, based on the prominence and the prominence of the defense attorneys, if these had been local attorneys, your sort of average criminal defense attorney from, name where they hang out in, Miami, coming to you and pressing for this, you, writ large, the department, do you believe they would have had the same or a comparable level of access? So, I don't know the answer, I'm asking. Yeah. So I guess I respond this way. If an attorney, after meeting with my management staff, asked for a meeting with me, I believe I did and would have granted it, and I can think of several matters on which those types of meetings were granted, and so that was not unusual. Alright. With respect to the back and forth after the agreement was signed, this was an unusual agreement. And to some extent, as a result, the back and forth quickly elevated, particularly because matters would elevate, in particular, when they were being addressed at main justice. That would be one natural way for matters to elevate within the office. And so, the fact that they were being addressed and reviewed, and letters were coming here, would naturally elevate the way the matter was being treated, was treated in Miami. In particular, Jay Lefkowitz had ready access to... Of course, he was involved in the negotiations with Redacted directly in creating the NPA, but after that it appears from the record that he was often contacting you and running or going above the people who worked for you, and on numerous occasions you, again, my characterization, reprimanded him or instructed him not to do that and to direct his communications to the line attorney or her supervisors. Is that a fair characterization? Yes, I think on several occasions I said direct them, and again, that was after the agreement was signed, but yes. There but there were many issues still pending, correct? Yes. Okay. And that was his ability to reach out to you as a function of your personal association. Is that fair? So I don't think that's a fair characterization. I think you could also say that it was the ability of a function of his insistence in not doing what we asked, and the fact that in a typical course, a Miami attorney would not have done this because they would have had to interact with the office on an ongoing basis. And so the repeat litigator believes very differently than the one-time raised earth litigator. Raised, R-A-Z-E-D? Correct. Is it reasonable for us to understand that you have followed the media coverage of what happened in the Epstein case over the years? Yes. In your view overall, and in whatever specific respect you wish to address, has it been accurate or not so? I think it has been inaccurate in several ways, and we can go through them, but if you could just tick those off. So I think it's inaccurate in that it has been characterized as our approving a state plea, and the complexity of this case was a state plea, and we were deferring to in favor of a state prosecution has been lost, and it's something that I have attempted to correct, but it's very difficult to sort of explain that in the media. You know, this is a bad analogy, and so I haven't used it in the media, but I thought about it, and so I'll share it. So after the Jesse Smollett plea in Chicago, there was some discussion of whether the federal government should bring charges, and I remember the media saying that, and I haven't used this analogy because I don't want to compare, and I think it would be disrespectful to compare the facts of that case to what happened to those victims, and I don't want the comparison to be drawn, but there is a legal comparison, right? The US attorney in Chicago could have stepped in and said, whether or not the state takes this plea, we may investigate this federally and sort of stop that plea from going forward, or at least put a wrench in those gears. Or the US attorney could have pursued that under petite policy and did not. And so our stepping into this sort of reminded me of how many times cases that are viewed as a manifest injustice do occur, and yet the federal government does not step in. And the fact that we stepped in has been construed as this became a federal prosecution and sort of going to, is it redacted or redacted? Redacted. Redacted sort of question earlier, the distinction between it was not a manifest injustice versus this was the right outcome is something that I think has been lost in the coverage of this matter. I think a second issue that has been lost in the coverage of this matter is there are references to Prince Andrew and Alex Dershowitz and Governor Richardson and Bill Clinton, and things happening in London and the so-called Lolita Express where things may have happened on airplanes. And so this is viewed from the public as this international matter where the victims were local, the actions, to my recollection, was local. And so the distinction between this Palm Beach incident and what the media likes to cover, which is, did Mr. Epstein force a minor to have sexual relations with Prince Andrew, is a very different fact pattern both in terms of the public perception of forcing a minor to have sex with a third party that they have, that is outside the solicitation context. It's sort of, I'm travelling with these women and forcing them to have sex versus a more local matter that, I don't want to say solicitation because I think we've covered that, but that some may view as that. And I think those are two major elements, right, that have been lost in the coverage. The case has been criticised as having involved improper influences or favours, or payments that affected decisions that were made within your office, and you're aware of all those, allegations as well. In connection with this case, were you yourself ever offered any payments or any favours, or any promises or job assistance or anything like that? No. In connection with this case? No. And to your knowledge, was there any such offer to anyone associated with this case in your office? Not to my knowledge. It's been asserted also that the handling of the case in the office was affected by Epstein's wealth and influence in the Palm Beach community. What's your response to that criticism? Again, my response would be, sometime in May or June, we came up with these 3 points and we stuck to them. And despite all of this, when people make these assertions, somewhere along the way, the fact that we stuck to those points is lost and it's not talked about. And so we did stick to those points, and question whether the case would have come to us in the first place, I think that could also go the other way. I don't understand that. That it's highly unusual for a case to be brought to the US Attorney's Office after the state attorney fails to fully prosecute? Right. And so one question that also doesn't get asked is, to what extent was this case brought to us in the first place because of his profile? In other words, are you suggesting that his wealth and influence in the community affected the state authorities? I'm not suggesting that. What I'm suggesting is the case came in, the case proceeded, and someone can make the argument that the only reason that Chief Redacted brought it to us was because it had such a high profile. Are there other matters that take place in Palm Beach that a state attorney declines in the first place that isn't brought to the state attorney because it doesn't rise to that. You mean to the U.S. attorney? To the U.S. attorney because it doesn't rise to that profile. All right. By misredacted. Well, in fairness, he might have done it because of the number of victims too, right? He may have, I don't know. What I'm suggesting is we try to treat it fairly, not looking at, hey, how wealthy is he, but also not saying we need to do this because he is so wealthy. By misredacted. What do you think about the media's treatment of the line assistant? Redacted. I wish her name wouldn't be in the media. You know, to some extent, U.S. attorneys, when they take the job, realize that part of their job is to take the slings and arrows. You know, and there are instances where officers were accused of misconduct, and I always sort of felt that was, I don't want to say below the belt, but that's not why they take the pay cuts that they take to go into federal service. And, you know, I think the media coverage of this case has been unfair, and has lost a lot of the complexities. It's not surprising because, I mean, here, we're talking about a lot of those complexities, and it takes a fairly sophisticated discussion, but I think it's particularly unfair on redacted. In your attorney's written response, he used the term relentless to characterize the team of lawyers, the defense lawyers, and in that Daily Beast article that you wrote, you referred to the year-long assault on the prosecution and the prosecutors. You noted that the defense was more aggressive than any of which I or the prosecutors in my office had previously encountered. You noted that the defense investigated prosecutors and tried to disqualify two, and I believe that those two are redacted and redacted. That is correct? All right, yeah. And you also noted or asserted that there were investigations into the family lives of individual prosecutors, accusations of bias and misconduct against individual prosecutors, and even the threat of a book on prosecutorial zeal. Do you still regard that characterization as accurate? I do. You know, whether I would use those same words now, we can spend a lot of time talking about it, and I want, alright, to think about it. But I do think that's accurate. I think this really was a raised earth type of matter. And in the office's typical interactions, the prosecutors know they have to come back to the office. And so they were not... Sorry, not the prosecutors. It's getting late, though. The defense counsel. And so they were not... It's not just the accusations against the attorneys, but the mischaracterization. I could go through the record, and there's several instances where my words or other authors' words are being mischaracterized, or where, going back to one of the redacted emails, people walk out of the meeting believing they have an agreement, and then they're unwound, and that is not... I don't know if that's typical in Washington, but that's certainly not typical in the Miami office. Alright. In that Daily Beast article, I think you also used the term peccadillos. Yes. What did you mean by that in particular? Could I see the... I was afraid you'd ask that. I have it right in front of me, and I don't at the moment. But... Misredacted. Are you talking about the To Whom It May Concern letter? Misredacted. Yes. Yes. The witness. Yes. By misredacted. Yes, thank you. And it's a reference on the second number page of this copy to personal peccadillos in the middle of the page. Also, individual prosecutors and their families looking for personal peccadillos that provide a... So, redacted was, to my recollection, she wasn't investigated. Redacted. Big redactions here. And I haven't encountered that in other cases. I recall it, at one point, they also looked in Redacted and Redacted's family and his background, and I thought that was a little out of line. Oh boy! Wow! Okay, this is a lot of redactions here. What is going on here? So, the context of the matter, they are talking about the personal details of prosecutors on the prosecution team. So, I guess... From what I can see so far, yes, some criticism can absolutely be levelled on the prosecutors for not pushing as hard as they could, but the actions of the defence, I mean, they had Alan Dershowitz, he had very, very high-profile, powerful lawyers on his side. Epstein had so many good lawyers on his side, and a very, very good legal team. And he's confirmed here one of the best, or one of the most effective, or one of the most aggressive. Do you think they cross the line into completely unethical? I think so, because of the way they kept pushing back the plea date, wanting to always change something in the deal, and they speculate potentially so the girls get older, and thus it doesn't look as bad to the jury. That's what I'm thinking anyway. So I'm just looking at something else here. Alright. Big redactions here. QA, QA. Big answer here. QA. The A is an I. And this is redacted. Another redaction. Fucking hell, this is a lot of redactions. And this has been noted heavily in red. So this is big info. Like, this has been labeled several times. Like, what's going on here? Okay, so it carries on here from an answer. But the point I was trying to convey is this is not typical behavior by defense counsel. So they're redacting what the defense counsel did, which isn't a good sign, I don't think. Yeah. But the point I was trying to convey is this is not typical behavior by defense counsel. Did, and despite all this, my point was, despite all this, we did not budge. And again, that's not the focus of this question. More big redactions here, holy shit. So, so this is the context of stuff, from the context of what the defense team has done. Yeah, I think, yeah, I mean, the prosecutors, I think they should have shown a bit more backbone, a bit more spine, not cut a deal. I think the court process, at the very least, would have worked, but yeah, I mean, I guess if they're questioning the reliability of the witnesses, they might want to take a gimme, but that's not ethical at all. They shouldn't have done that. They should have absolutely taken it to trial. That's unfortunate. Anyway, carry on. All right. Are there any other examples where defense counsel came to you that you have not otherwise been addressed with? Allegations about someone. I'm hesitating. Else. Just because I'm trying to think through and not to my recollection, no. Did they ever raise or imply that there was information regarding you of whatever respect that was in the nature of a sort of a threat or a veiled warning? So the book reference was that I might be personally embarrassed by pursuing this matter, because I would be the subject of a chapter in a book on prosecutorial overreach. And who was going to write that book, do you know? Professor Dershowitz. He was on the defense team. Okay. Did you consider him a professional friend at all? I had not to my recollection met him. I understand in this letter I sort of grouped him in. But I say for the record that it's hard to know what my intent was in 2011, but that's for simplicity of grouping individuals because I did go to Harvard. I may have run into him in Harvard, but he was not my professor, and I didn't work for him as a teaching assistant. I had some interest in criminal law, so I may have chatted with him, but that would have been it. And did you consult with him at all in connection with your efforts? Your interest in potentially teaching or being involved in the sort of the law school world, either at Harvard or at Florida International or anywhere else? Not to my recollection. At some point when I applied for the deanship, I wasn't aware of the deanship until... So let's take this in part. I thought about looking at Harvard for a teaching position. To my recollection, I never followed through on that. I knew Elena Kagan, and may have had a conversation with her. That would have been a preliminary. How does this process work? But I don't recall taking it. If I took it that far, and I'm not saying that I did, this was a long time ago. I never sort of went through... The way law schools hire is a very... They call it the meat market. And take that for what it's worth. It's something that happens at the hotels here, at the Marriott here on Connecticut. There's a very formalized process, and I never... went through that. I don't recall any conversation with Professor Dershowitz about that. To the extent I was thinking about it, it'd be natural for me to talk to Redacted, but I don't recall talking to him. With respect to Professor Dershowitz, with respect to FIU, the dean process is very decentralized. To the extent a faculty member spoke to him, I don't know. To my recollection, and again, this is a long time ago, I did not ask him for a reference or a letter or something to that regard, although I may have. It was a long, long time ago. I was also no longer active in this case at the time. Alright, and what about with respect to that same process on your part? Ken Starr, who actually was a dean of a law school at the time. Did he provide you with a reference, or not? Hang on, sorry. I'm just putting I'm putting my smart ring on my charger because I forgot to charge it. Not advice? Not my recollection. Alright. As a letter from Ken at the end, there was some... By the time this was over, there was some degree of tension between us on my resolution of this matter. But it also appeared to be tension that both of you were eager to leave aside. I'm a big believer, and I had good relationships with the defense bar. I think lawyers can disagree and not be disagreeable, and we will be a better profession if we all learn to do that. So with the world, yes. There is an sort of investigative journalist author named Redacted. Yes. Do you know that name? Yes. Did you ever speak with her? So she was the recipient of the Do Whom It May Concern letter at the Daily Beast. Oh, really? Yes. All right. Thank you. We didn't know that. Did she comment back to you on it? It was a long time ago. I don't recall. So she wrote a book called Trafficking. Have you read that? She did. About this case? She did. I haven't read it recently, but I read it a while ago. And she says in that book that you told her a few years after the MPA was signed that, as she writes, he felt incapable of going up against those 8 powerful attorneys. He felt his career was at stake. Did you say that to her? Not to my recollection, and what I tried to do was, for the record, provide this letter to her, and the purpose of this letter was to say the exact opposite, which is, and we have this, and she in the New York Times, and I think the New York Times called it, what's the word? Like, apologia? Does anyone know what? Apologia. Apology. It's a fancy way of saying, explaining yourself. Yeah, I looked it up, and it's a little more derogatory than explaining yourself because I felt a need, to look it up. But the New York Times called this letter an apologia. And this was recently. And I say this because when folks read this letter, they read it as, this is why, we had these, I think sometimes they selectively read language, the prosecutors and agents in this case, and what followed was a year-long assault. I use the word assault as it was more aggressive than anything in which I or the prosecutors in my office had previously encountered. Excuse me. Mr. Epstein hired an army of legal superstars. Harvard Professor Dershowitz, former judge and then Pepperdine lodging Ken Starr, former deputy assistant to the president, then Kirkland and Ellis law partner Jay Lefkowitz, and several others, including prosecutors that formerly worked in the U.S. Attorney's Office, the Child Exploitation Section. I'm not sure who that was, of the Department of Defense, and the Department of Defense? No, in the Child Exploitation and Obscenity Section of the Justice Department. Defense attorneys next requested a meeting with me, and they read that as saying there were all these powerful lawyers in this case, but they don't then go on to talk about, despite this army of attorneys, the office held firm to the terms first presented to Mr. Black in the original meeting. So what I understand you saying is that the panoply, this pantheon of attorneys, did not have the influence on you that's alleged? And the purpose of this letter was to say, despite all this, right, we held firm. So how can you say that there's influence if we held firm? I would also note, and I think we talked about this, that those terms were developed before many of these individuals came on board. So it's not like these terms were developed because, now these individuals are on board. All right. And we haven't, of course, talked about the whole work release issue, but yeah, I think that speaks for itself on that. Yeah. By Miss Redacted. So I'm not sure I'm clear. Did you have an interview or have a conversation with Miss Redacted aside, or just send her this letter? I spoke to her briefly, saying, I'm not going to speak on the record. I'm not going to address even off-the-record details of this case, but I will provide a letter to you. I've had a lot of requests over the years to talk about this case. There were enough requests coming that I thought it important to provide a statement to defend the actions of the office. I didn't want it to be to one reporter in particular, because I did not want to play favourites, and so I provided a to whom it may concern letter that was a public letter, but then I gave it to her. Miss Redacted. All right, go on. By Miss Redacted. And just one thing on the... Oh dear. How do we do that? And just one thing on the work release issue. Did you tell the defense that the U.S. Attorney's Office would not object if he got work release, as long as he was treated like every other defendant? So I don't recall what I may or may not have said specifically around work release. My recollection of our general position is, your pleading in state court to incarceration of 18 is now 18 months, it was 24. Whether it was 18 or 24, this would have been... Any conversation I would have had would have been after the agreement was signed. It's our expectation that he be treated just like everyone else, if it was typical to provide that kind of work release in these cases. That would have been news to me. I certainly would not have expected that, and I think based on our subsequent communications with the State Attorney's Office, that was not what our office envisioned. By the same token, I don't think our office envisioned that he be treated worse than the typical offender. Well, did you know that Redacted was in fact trying to make sure that he didn't get work release? Yes, and so I don't see any reason why I would have contradicted that, is my point. Oh, fuck, Oh, God! Oh, God, I've got a numb bum. All right. You've mentioned a number of times that the sexual offender registration was one of the three important prongs for you in the office. Yes. What was it that you saw the sex offender registration as accomplishing? So, to some extent, it's putting the community on notice that, irrespective of whether he's in Florida or elsewhere, he's a registered sex offender. To some extent, I don't know if this is, but I'll say it anyhow, this was a serious crime, and there was a public sanction associated with this, and I thought to the extent that he committed the types of acts that typically are associated with registration, that should go forward. But the primary motivation there was, put the public on notice that he is a registered sex offender. And did you see any conflict with that as being a goal with the provision in the MPA that the MPA was going to be kept confidential, and the communications in which the U.S. Attorney's Office was having with the defense about continuing to keep things confidential? Do you see any inconsistency between those two? No, in that I generally was of the opinion that this MPA would go public, and certainly his state court plea would be public, and his registration would be public, and so what he did would be known. And given what you know about these offices back and forth for notifying the victims, do you think, looking at the entire course of conduct of the office, that the victims were treated fairly, and with dignity and respect? So I want to be careful, not because I'm fudging, but because it's a complex question. If, looking back in hindsight, we knew that there would be a 8 months period, when do we have an agreement? Do we not have an agreement? Is this concluded? Is this not concluded? Is this an ongoing investigation? How do we deal with all these notification issues? If we have foreseen all of that, I think I've said before that that's something I certainly think should have been considered, and it's very possible we would have done something very different. But that was not foreseen, and so it's then a very difficult judgment to be made, because there is an agreement. There is concern as to, if we have to go to trial, how do you address this? There is, going to the redacted affidavit, at least one instance, and I'm merging my recollection here, and my knowledge after the fact, because your question sort of calls for an after-the-fact assessment. So you've got the redacted affidavit, which points out that defense counsel did all they could, but is using this to impeach and weaken witness credibility in a case where there's already questions around witness credibility. And so it's a very imperfect situation with discretionary judgments to do the best to sort of balance all these factors. Is that the best outcome? Probably not. But that's where we were. And that's why I think this case would have been very differently if, October 24th? He would have gone in and pled and taken his time and served his time like so many other people have done, as opposed to mount all these legal challenges that we then had to work through. And I'll preface my question with the fact that we're still investigating this. We've made no conclusions. With respect to this. But if OPR determines that your office should be criticised for its handling of this, matter, does that criticism fall on you, or does it fall on your senior managers? Because as a non-prosecutor, you are relying on them to keep you informed for their judgment. So I was the US Attorney. I certainly relied on my staff, but ultimately I was the US Attorney, and I don't think it's justifiable or fair to sort of say this was on them. I was sufficiently aware of matters that it was my office, and while I'll say that I might not recall this, or I was relying on A, B, or C for guidance, or to handle this matter, ultimately I think those judgments always sort of bubble up. By misredacted. In your press conference, your reference, this is the, I think, July 10th, 2019 press conference, you reference victims. What they went through was, horrific, you said. And then you said, I have seen these videos. I have seen the interviews. I have seen the interviews on television of these victims and their stories. Just to be clear, are you talking about interviews and television coverage and videos recently? Or back in 2006 and recently? 2007. Okay. I just wanted to be very clear about that. The US Attorney's Manual requires us all in the department to conduct the fair, even-handed administration of the federal criminal laws. What's your view as to how the handling of this case comported with that principle? So, I do think it was fair and even-handed. We, after the fact, may look back and say that 2 years may not have, it shouldn't have been a manifest injustice standard. It should have been, a sort of a de novo. Let's treat this as a new prosecution. That's a judgment you all make, but those judgments were made with an eye toward fairness and impartiality, and once those judgments were made, despite all the attorneys involved, and despite all the litigation, and all the stuff, all the appeals to Washington, and we stuck to that position. And I think that speaks to the way the office approached this matter. Alright, we We spoke sort of offline earlier about an issue that was raised in that press conference that was not clearly answered on your part in that context. And the question was, and this is on page 15 of the internet transcript of, that press conference, you were asked whether you were ever made aware that Mr. Epstein was an intelligence asset of some sort. And you in your response, you said you couldn't answer it, couldn't address it directly because of guidelines. Can you clarify, first of all, were you ever made aware of that? If he was, assertion. I'm not aware of it. Alright. Did defense counsel ever say to you that Epstein had that status? Not my recollection. Alright. And to clarify, I also don't know where press reports from multiple sources, not from multiple sources, but from multiple media outlets that I told someone that he was an intelligence asset. I do not know where that came from. If I can just... So there are questions that I may be asked publicly that I don't think it's right for me to comment as to what classified information I may or may not know, because that's not the kind of stuff you go into, but the answer is no and no. Alright. Without reservation, without any no and no. Alright, excellent. Thank you. A couple of final questions. As you can tell, can I, yes, address a second issue that has come up at times? Yes. There are also media reports that this was because of cooperation in some financial matters. I don't know where that may have come from. Alright, thank you. And we are familiar with that, what you're referencing to. What you're referring to, sorry. Was there cooperation related to financial matters? We didn't ask you about it. Okay. As you can tell, ODR obtained many electronic records. Yeah. Mainly emails, but other electronic holdings from the department. The Department of Justice, however, has not been able to find or recover a portion of your email account as U.S. Attorney that contained emails received by you between May 26, 2007 and March 2008. Correct. A period of time rather relevant to this. We have obtained many records, of course, from senders and from other people copied. So we may have many of the records, but the fact is, that's a gap in the holdings. And this is despite the fact that, as you no doubt know, the law requires that U.S. Attorney records be maintained and archived. Right, indefinitely. Can you give us any insight, any idea why that might be the case? I can't, and my recollection was after several issues that took place, the department had some sort of records retention software that automatically retained these emails. Is that not accurate? There was a switchover from... Right. A period in which that record retention responsibility resided with each U.S. Attorney's office, and at the switchover, it became centralized. Right. And this appears to have sort of gotten lost in being caught in the switchover. My recollection is that there was some automatic retention mechanism. Okay, and I can't address that, although there's certainly a fulsome record. But just to ask the inevitable question, right, did you take any action to discard, destroy, or dispense with any official records? Not related to this matter? Not to my recollection. I think there's a fulsome record and not to my recollection. Alright, and is there any particular gap that you've discerned in the records that we provided to you? Not that I recall. Do you have the emails that I sent out of curiosity? We do. Okay, so you have the sent but not received. Yes, just checking. And likewise we retrieved from the Federal Records Center, right, records that were boxed up and sent there, hard copy documents, after your term ended, and there is nothing that relates to the Epstein case. There were records that were maintained that were kept in the main office, right, after you left, because it was an ongoing matter, but do you have any idea why there are not any in the records of yours? So, none were sent? So I have a recollection that when I left, there were some binders that I passed along to Redacted, because it was an ongoing case, and we sort of had binders out that sort of had correspondence back and forth. Alright. And you've already made, I asked you about facts, but you addressed a sort of broader statement to us for the record about the case. Is there anything else you want to tell us at this point? Give me a second to, sort of think this through. In fact, if you'd like to take a quick break and talk to your attorney, and that will be the last question. Do we need a break? Mr. Redacted, no. Miss Redacted, your attorney says God no. The witness, I will follow up on this. Miss Redacted, alright. The witness, nothing that if something comes up, my understanding is that we've received the transcript and have enough time given the length of this to review and comment. By Miss Redacted. Exactly, yes, and for the record, right. When the transcript is prepared, which should be within a couple of weeks, we'll ship that off to your attorney. We'll ask you to review it, to make not only any corrections, but also clarifications, and to add to it. If you feel having read something that it needs to be clarified or expanded upon, you're invited to do so. And if I could ask one other question, is there... I'm not familiar enough with the way OPR operates, and this may be sui generis, so you may not be prepared to answer. If there is a report, as opposed to a letter, which is what I typically am familiar with, will that report be shared in advance for comment? I'm going to... Or is that to be determined? Ms. Redacted. I'm going to defer to Ms. Redacted for that. Ms. Redacted. That's a question that doesn't need to be on the record. Do you have anything else that you'd want to put on the record before we close out? The witness. I do not. Ms. Redacted. All right. Ms. Redacted. All right. Thank you. I want to extend our great appreciation for your willingness. The witness. No problem. Ms. Redacted. To come in and help us with this case. The witness. So let me... Now that we're off the record, let me say... Ms. Redacted. Are we off the record? The reporter. Not yet. The witness. Not yet? Oh. Ms. Redacted. No? The reporter. You didn't say it. Ms. Redacted. All right. That's it. We're off the record. Whereupon, at 8:38 p.m., the interview of R. Alexander Acosta was concluded. Certificate. The United States of America, in the District of Columbia. I, Beth Roots, notary public, before whom the foregoing deposition was taken, do hereby certify that the witness, whose testimony appears in the foregoing pages, was duly sworn by me, that the testimony of said witness was reported by me by electronic record, and thereafter reduced to typewritten form, that said deposition is a true record of the testimony given by said witness, and that I am neither counsel for, related to, nor employed by any of the parties to the action in which this deposition was taken, and further that I am not a relative or employee of any attorney or counsel employed by the parties thereto, nor financially or otherwise interested in the outcome of this action. Beth Roots, Notary Public in and for the District of Columbia. My commission expires April 30th, 2020. Oh, well, that is that for that entire fucking wad of a deposition. Alexander Acosta, that's his name. Or A. Alexander Acosta. I don't know. That's his name. But yeah, that's basically what we spent the last 3 streams doing it. Oh, we got a few more things in the chat. Section of the show currently reading was how the outrage of how light the sentence was. Yeah. And, you know, we've seen plenty of reasoning why that might be the case. To be fair, it should be pointed out that this guy being interviewed, the witness, they came in voluntarily, and they did this. So I will give him props for that at least. But yeah, he seemed to point out the very interesting thing was the redactions, and it's talking about the things that the defense counsel did that he did not like, and it might be that. It might be that they were a little bit scared to bring it to trial, but they also, I think they started off, as he says, they started off with sort of a plea, which may have been a bit too low. And I agree, I think he should have served a lot more time in prison. And certainly the victims, they deserved a lot more compensation. Yo, man, reading the files, let me tell you, this stuff is not even the tip of the iceberg. This is just the cherry on top of the horror sundae that is the stuff that hasn't been released yet. Well, if it hasn't been released yet, how do you know that? It could be just like 10 pages of Epstein likes puppies or something like that. How? I've been told there is still a boatload more that will turn your hair white. Who told you this? And turning my hair white? I don't know. Could I turn my hair white? I don't know. I think that would be a pretty good look for me. Respects for voicing this. Absolutely. Thank you very much. And all of this will be sort of compiled into one clip. One video, and that's probably going to be about, I want to say 6, 7, 8 hours. That sort of length of time. It was very, very long. But I'll clip it, I'll release it as its own separate video, and see what we go for. Yeah, I learned of Hawkins having been on the island from Net reading the files. Yep, he was. He was in the files. I always knew that guy was wrong from something. He felt very wrong and felt like someone else could use him as a voice. Possibly. I mean, Stephen Hawking isn't necessarily a saint. Bear in mind, he did cheat on his wife. I think he cheated on his wife, married. I think it was one of his nurses. Cheated on his wife, divorced, married the nurse who he cheated on her with, and then I think he remarried his wife or something like that. But you know. But yeah. But I mean, just because somebody is, I want to make this important distinction. Just because somebody is mentioned in the files, all that means, that doesn't necessarily mean they were involved with kids or did any of the horrible shit. All that meant is that they were associated to some degree with Epstein. Epstein knew a lot of famous and powerful people, but just because people knew Epstein doesn't mean they were involved in or trusted with the horrendous shit that was going on there. Okay, I mean, Prince Andrew was in his inner circle, sure. Stephen Hawking possibly knew Epstein. Epstein knew the rich and powerful. I mean, he even collected. I would say he collected association with rich and powerful people in a way. But it doesn't necessarily mean that they were involved in the heinous shit. As much as I do, not that you should necessarily joke about it, I do make light of Stephen Hawking being on the fucking files, because, let's be honest, how is he going to go about doing some horrible shit? And indeed, he's got nurses. He had nurses near him or around him at the time. But that said, I could be wrong. Of course, he could be involved as well. But also, I think David Copperfield was mentioned. But I think he was doing like a private performance for Epstein and a few rich people. Doesn't necessarily mean, as I say, that he was involved with kids. Or he was involved with the victims. Or he had any knowledge. So, got to be careful where to draw the distinction. But based on the evidence provided, some people likely had more association with Epstein and more knowledge of probably what went down than others. I mean, I know a lot of people like to mention Trump. I mean, I don't know. I'm British. I'm not involved in any political bias in that regard. Bill Clinton, yes. He's caught in so many photos, and including with potential victims as well. But there's also, obviously, we know Prince Andrew. I mean, Prince Andrew is very. Ghislaine Maxwell as well. Ghislaine Maxwell, who I should point out, is in prison and is refusing to name names or cooperate with the authorities. Let me just check. The unreleased stuff may never be released if the court's word is it pertaining to trials will never be released. Well, at the very least, if they do release it, they can wait until I've done this lot first and had a break. So I don't necessarily mind that. I live near a military base, and let's just say you hear things every now and again at the bars off base. A military base isn't necessarily the same as intelligence agencies or law enforcement, but I do see what you mean. A lot of military personnel do go into law enforcement, although it's a civilian field, so there's a lot of different things you need to learn. God, we're getting very active chat. Let me just read the rest of these, and then I'll carry on. There is no option to release material that names and details child-related acts. Well, yeah, I mean, you don't want to know the specific details of the heinous shit. You can use your imagination. Not that I would want to imagine such horrific acts. I just want to know who was responsible and to what degree. And also the victim details. I mean, absolutely, the victims need to be protected at all times. Virginia Giuffre was a very, very courageous woman who came forward with her real identity about what happened, and just. I suspect, with lawyers and all this media attention, I think there came a day where she couldn't cope, and that's when she allegedly took her own life, which is really, really sad, really, because I think when I read her deposition and when I read her testimony for the previous lot of Epstein Files in 2024, I very much identified with her cause, and I think that it was very spontaneous then and there. That I basically said, she mentioned a charity a lot. And I... Excuse me. I'm not tearing up. My throat's just dead. And she mentioned her charity a lot. And I basically just said halfway through the files, I'm donating all the money to her charity. That was how much it moved me. And, I carry on that promise today. Like, everything from all these streams and all that, and all the clips... That's going to go to our charity as soon as they accept donations. I'm just going to work out the total when that day comes, probably add a little bit extra to it, and just send them a fat donation saying, this is for Virginia. That's the big problem. The fact is the guy knew everybody. It sounds like he was some sort of governmental level fixer. I mean, people are mentioning he might have been a government agent. I mean, it even showed up in this testimony. Mossad, that's a bit of a stretch. American intelligence agencies, absolutely. He's an American. He knows a lot of people. He's an asset that they could lean on. Remember, Epstein helped Bobby Kotick push loot boxes and microtransactions in video games. I mean, I'd like to see the more details and the proof of that. If it is, I could probably do it as a separate clip. Don't get me started on Epstein killing free energy. Okay. Again, point out in the Epstein files all those different details, and I will cover them, and I will keep an eye for them. Pretty sure David Copperfield was dating Claudia Schiffer back then. I wouldn't know. I've never seen David Copperfield, and magicians. I've seen. I remember like a show when I was really, really young. It's like Breaking the Magician's Code, and you had the masked magician. I was a kid back then, and I loved that shit. And I think that ended up being like Val Valentino. She didn't take her own life. She was helped. I mean, the official thing is suicide, and that's Australian authorities. Obviously, there's a lot of doubt behind it. I can believe either way. I can firmly believe that the pressure did get to her, even though she did say I'm not suicidal. I can imagine the pressure would have gotten to her at some point, and just the attention, and it would have been horrible having your name in the light like that. But I can also imagine the opposite as well. If she's able to name more names, for example, if she's able to do that, then sure, she would still be a threat. Although, having said that, I would say, she would have already given all the information to the authorities anyway. Maxwell's father used to work for Mossad. Yeah, Robert Maxwell. He was a crook. He was a UK British businessman. He might have had some other origins. I think he eventually turned his surname into Maxwell because I think he was an immigrant or something. But he was an absolute crooked businessman. And I think he died before I was born. His boat, the Lady Ghislaine, which he named after his daughter, boating accident, and he drowned and he was declared dead. But turns out, he was fucking around with pensions, he was fucking around with his employees' stocks and stuff. I think, he was an absolute crook. And I think his death led to sort of like an Enron kind of situation. And if you're too young to know what Enron is, Google it. You'll find some interesting shit. Anyway, let's go on to the next one. Okay. Oh, for fuck's sake. What is this? What is this? How the hell am I supposed to read this? What the fuck is this? My God. This I can sort of read, but bloody hell, Okay. Now, I need to keep drinking. My throat's very, very dry. Also, I think a little bit of... I think there's a little bit of reflux as well I've got to deal with. Hello, Dexter. You alright? Where's Clara? No, she's on her favourite cushion. The cats are both being very, very good. Definitely it's a very good idea getting that blanket. I did originally try to put it up on the top shelf because I know Clara likes to sometimes go up there. It was a bit too big for the top shelf, but I think I do have an option to get a smaller one, so I'm probably going to buy a smaller one, stick it on the top shelf, and maybe Clara will go up there, lie down there, and that's something people can see on future streams. Sorry, I'm not continuing, by the way. I will continue during the stream, but I just need a quick break. But Epstein stuff isn't the only stuff I plan on streaming. I plan to stream a lot more, get a professional setup, and hopefully just go a bit harder on certain other things, and get a bit more traction that way. Because I don't want to drop off. I want to sort of stay relevant, and people like live streams, so why not? I'll give it a go. I'll play some Helldivers, some proper HFY approved game, certainly. David Copperfield thinks this creepy stateside, even more so in the context of his charity work, involves a lot of work kids local to Las Vegas. I didn't know that. I'll check it out afterwards. Actually, I mean, if it walks like a duck, quacks like a duck, it's probably a duck. So if he's involved in a lot of dodgy shit, that I would say that probably increases his chance of being involved with Epstein. But then again, if he's just, It seems to me like the context I got was he was just putting on a private show or something, or maybe just met a few rich and famous people or something, or got paid for it or something. Yeah, I had a friend that worked for an escalated company with Enron. That would have been. I think eventually the feds got involved. I think they did try to dismantle Enron in a way that sort of things still worked, but it would still be a pain in the ass. I like the dragon. I like the Dragon too. This is a displate. I'm not sponsored by them or anything. Like, indeed, I've never accepted sponsors on this channel. But yeah, it's a metal poster I got from Displate, and it's one of their top-rated ones, and it's one of their popular ones. Last year was when I bought this place. I own my own home now. And so, yeah, I mean, I saved some money for decorations, but there will be some more decorations this year, just as and when my big purchases are sort of done, like tax and a car. Because I don't have a car yet. I know Americans will be like, what the hell? Everybody has a car, but obviously in the UK, my country, it's a much smaller country. It's also very densely packed. And before I came here, I lived in cities. So I lived in London for a while, and I lived in Bristol. And there's public transport everywhere, and it's not worth having a car. So yeah, I do know how to drive. It's just I've never needed to get a car. Now that's changed. I sent you a video in private chat of a toy I got for my cat, and she loves it. Ooh, I can't wait to see that. My cats, they like these like little plastic springs, and the weird thing is, I got those for free when I bought them like cat bowls or feeding bowls for the first time. Yeah, the private show was a thing I thought of as well. Yep. Thank you for the HFY. Yeah, no problem. I'm glad to entertain. You live in the UK? I am so sorry, dude. Don't even get me bloody started. Like, things are kind of bad over here, but we have avenues to make things better. I'm sure, you know, I'm not going to tell you how I would prefer for things to get better. I will simply say that there are avenues for things to get better. You can take that however you can. As I say, I normally don't discuss politics at all in this channel. Like, I try and just cut it down the middle, because, you know, I'm representative of a lot of people, and that's not my focus. Dated a lady from London who never got her license until she moved to the US at 35. I mean, don't you need a separate license in the US anyway? Because bear in mind, in the US, you guys drive on the opposite side of the road from us, so that must be hella confusing. Honestly, if she only got a license in the US, that's actually probably a good thing. Because, like, if you're an experienced driver in the UK and you move to the US, which I'll admit I have thought about, you have to get used to driving on the exact opposite side of the road from where you've been driving for so long. For me, it would fuck my mind up completely. Although, having said that, if it was me, if I did move to the US, I'm not sure where I'd move. Indeed, the circumstances in which I'd move would probably be like, you know, if I happened to date and marry an American for a long-term relationship and I move back to the States. You know, States I would move to. I don't know. I mean, Vermont sounds interesting, purely because of all the maple syrup, but, you know, Texas sounds cool. Florida sounds like a magical place. Not California, though. Fuck California. Anyway, I've rambled on for too long. But no, those are just my sort of ideas, and I think if I did move to the US, small town, no big cities, I don't want to deal with traffic or, you know, high rates of crime. You know, as long as I'm able to get Amazon packages, because that's the one thing I love here. If it is like, I don't need to just be like, oh shit, I haven't got this. I better go drive down to the shop. No, I just buy on Amazon and just have it delivered. You know, so much easier. But I know some places in the US are so remote they don't have that, and they have to drive like 2 hours to get to the supermarket or something, or like a Walmart. So yeah, fuck that, fuck that. But then again, having like a farm or some land that I could plant stuff and you know, make a living sounds fun. But you know, that's just a pipe. That's just a pipe dream. For now, I'm quite happy with my property and my 2 little kiddies. Florida is nice. Check out Gig Harbor. Okay, I will do it later. I've been stalling for too long. I'm gonna try and carry on with a few more of these, and then I want to get to a decent point where I'm able to reasonably finish off the rest of Dataset 7 next stream. And next stream it probably won't be tomorrow, because tomorrow I've got a it's not a D&D, it's a tabletop game. I joined a tabletop game. I might actually stream it like in the afternoon on Saturday, like early on Saturday, and just make sure I get the whole thing done, and then Monday I can just start with Dataset 8 or something. I don't know, I'll see. But certainly I do want to get a move on with this. Which is why I'm not reading it at the moment. Alright, let's get back to it. Electronic court reporting witness log. Stevie, crimes against children investigation. ASA. Lana Belolovec. Date. This is all 7/19/06. ST or DVS is all TT. Witnesses, bunch of redacted. This is a detective. Direct, 9/14/1A, 11/11/15. Same again, I suspect. 9/21/04, 11/34, 8/9? What? Or it could be 09. 11/56/34. And this is redirect 10/00/28. Redirect continued 11/32/08. Yes. So I'm assuming these are when witnesses are called forth, or something like that. And so 9/20/47 to 10/58/28, and then 11/34/14. What? 11/31/32, 10 o'clock, 11/54/32, 12/14/56. Okay, unless of course this is the same witness, the guy we just spoke about, but these are all like off the record kind of stuff. So they did go for a break several times, and this does match it up. And this is continuing investigation and review of grand jury directives dated 4/25/06 ASA Marianne Dussen. Oh no, this wasn't the last guy, because this was no, actually it was, because this is 2019. Sorry, the American dating system is a little bit unusual for me. So this was the previous guy, because this was recorded in 2019. I think January, February, March, April, May, June, July. It was before Epstein killed himself. I think Epstein killed himself on 14th, which would have been 08 rather than 06. I think. Don't quote me on that. I'm just recording that from memory. Continuing investigation and review of grand jury directives dated 4/25/06 ASA Marianne Dussen. 7/19/06 TT redacted. 1/17/22 1/39/51. Beach Conference, motion strike, Assistant State Attorney Lana Belolava and Marianne Dussen. Confidential. And Jesus Christ, just when I thought things couldn't get worse. How is anybody supposed to read this? Well, page, I can't even tell it. You would think it's page 1, but 7/19/06. I want to say maybe that's Hazel Lucy? I don't know. Criminal against crimes against childcare investigation. TT. Oh, that's Lana Belovovic. We've seen that name before. So 9/14/12 to, oh Jesus, there's more. 9/13/12, and we're gonna to 9/13/12 to 1/39/51. I don't think these are different days, these are times. Yeah, so we're not going to go for the dates, we're just going to... How the fuck am I going to read this? What is this writing? This is... No joke, this is the worst writing I've ever seen in these files so far. Like, it looks super posh cursive, but it's just... Yeah, I will try and read this to the best of my ability, but I'm going to try and go for it slowly. I'm going to try and zoom in a little bit as well. So if anybody in the chat wants to add their own insights, or if anybody watching the VOD that will result from this want to add their own insight, they're more than welcome to. Indeed, this whole Epstein stuff has been very much a community-wide investigation. It's not just me doing it. There's plenty of other people bringing attention to that, and shout out to my fellow creators that are doing their bit to hopefully bring these people to justice. But yeah, if they have any ideas what they say, I'll be very glad to hear it, because goddamn it's bad. Anyway, on record. TT direct dot redacted. Walimi revealed on case. Key came to PBPD. What redacted thought was giving on. Redacted. This is illegible. With phrase Frank Palm Beach. That says Palm Beach. I'm assuming. I think this might be shorthand for witness. Witness redacted. Lacey interviewed. Paid initially. Is this victim or witness? I don't know. What the fuck does that say? Please tell me if you think you know what that says, because I'm open to all suggestions at this point. And something told redacted about going to the house. I'm assuming this is witness or victim. Based on the context, this is probably talking about the witness or the victim. Man investigated as potential Jeffrey. I don't know. Redacted said she was 18. TT Direct redacted. Agent Guns was redacted. New Rescue redacted. New Next redacted. Oh, fucking hell, this is bad. Redacted paid and would meet Jeffrey. I can sort of read that bit. The black bars I know are probably names. I'm looking for what this cursive says, because this is... No joke, this writing is very, very difficult for me to read. And told assistant lady she was 18, I'm assuming. Jeffrey's full name, yeah. What was Jeffrey's name? Went to something? I don't know. Jeffrey said lady appears to back door. Yeah, so the way they do it, the girls will come in the back door, they start in the kitchen. And that's where they'll be met. I'm just trying to add some context. I'm not sure if this is what it actually says. Assistant lady walked out with the... walked up the stairs. Yeah, walked with up the stairs. Okay. Anti-direct continued. Lady told to wait to... Told with to keep his party's ex? I don't know. Jeffrey laid down on his belly. Oh, this is fucking hard. Jeffrey's description. Okay, I'm assuming. What was something of hesitant? I'm assuming that the victim was hesitant. Told Jeffrey she was 18. Gave Jeffrey a massage. Assistant lady asked witness to undress. So the lady did. So that's possibly Maxwell. Something technique Jeffrey's better. I don't know. Jeffrey's actually redacted. Yeah, I'm assuming that's the acts themselves. Jeffrey lay on his back. Where did Jeffrey redacted? Jeffrey redacted. Something. Jeffrey gave her $300. Was because about telling detective about redacted or something. Who was desensitized, maybe? Redacted got money too, maybe $300. So this was the act of, if a girl was already in Epstein's web and kept coming, they would also be offered money to introduce a new girl. And that was how it worked. That's how he expanded his web. That was his modus operandi. Deceived with... Or I think this says deceived with redacted what happened. Did redacted... something asked about doing it again, I think. The victim was asked, you want to come again? And she did not go back. Good. Made something call to redacted. Or cancel call to redacted, I don't know. Or collect call. Told redacted, get redacted with redacted. Okay, so she was told, hey, bring this friend and this friend along or something. Why lie to assistant principal? Assistant principal called witness... Assistant principal called witness, I don't know, prostitutes maybe? I mean, I can understand based on the context. Fucking hell. I mean, this might end up being like a policeman's notebook, and they type it up later. So if this is typed up afterwards, I'm going to be pissed. Told people she used redacted, has dispersed with a count or action. No. Wit? What? Something addressed. Dad took her to get redacted. Did redacted? Did... put incense at $250,000 something. This is the same as well. Lucky eye or something like that. It was she was aware that it was a crime, or was aware that it was a crime. Okay. And this is off record here. What this repeats several times. TT direct dot redacted continued. What focused Jeffrey's house? Fucking hell. Matters made by something redacted. Two girls. Two girls identified. That's what that says. Had something guidance, maybe? Oh no, how old girls were. 9/21/05. Trash pull from Jeffrey's house. Yeah, I remember that. They basically disguised themselves as garbage men and went around and saw what was in his bin. What found in the trash pulled? Managed guys. 10/3/05. Trash pulled from Jeffrey's house. Yeah, they keep doing this. They'll do this a lot. Direct, yep. When talked to redacted, or redacted was paid, Jeffrey's assistant's name is redacted. Had redacted meet people that led her to Jeffrey. Who redacted took to Jeffrey's house. Yeah, these are, friends of friends. Or associates of associates. Redacted, paid. She was like Heidi. Oh, she was like Heidi Nice or something like that. I don't know. Maybe she's comparing her to a celebrity or something. Redacted was paid $200 every time she brought girls. Maybe. Oh, fucking hell. God damn. What additional things did they had? What happened? I think that's the context here. How many times redacted met at Jeffrey's house? Do you know how much Jeffrey was paid? Where lived redacted? Redacted said, take girls to Jeffrey's house. Hundreds at time? I don't know. Heidi Flass. Let me have a look. Yeah, that checks out. I think that does. Heidi Flass, maybe. Or Heidi Fleiss. There is a dotted I there, so yeah, it's quite possible. Something paid something. I mean, we know what's happened at this point. Jeffrey introduced his assistant. Redacted described progression of sex. Fuck. Redacted plead. Redacted. Or pled him to. Well, I'm assuming pled him to stop or something. A bunch of redactions here, presumably going for the horrific stuff. Asked redacted what did she do with the money. Who redacted something paid and case taken to Jeffrey's house. Redacted was 17 at the time. Okay, I think there's 9 pages altogether. We're on 5. Redacted said sex became more involved. So yeah. Now he's hooked him in. He's just got to escalate. Did Redacted tell Jeffrey she was 17? Did any girls tell Jeffrey they were under 18? I don't know. Knew something was that Ghislaine, maybe? I don't think if an officer's taking down notes, he would know how to spell Ghislaine. English was something. I don't know what that says. Intoxicants given by Redacted. Someone kept notes like a journal. Yeah, like a journal. When something taken to Redacted. Something training by guide for massages. I mean, we did see earlier Massaging for Dummies or something like that. That entire book was evidence, so we couldn't unfortunately read that. But yeah, it could be that, is Massaging for Dummies or something like that. Because we did see that book. Redacted, something with Jeffrey. Dear message by Redacted, go beyond. You guys knew each... Yeah, how girls knew each other. Okay. Attained... Oh, fucking hell. Attained something warrant for Jeffrey's home. Who used present with Redacted when something warrant. They found... Oh yeah, this is when the warrant was when they raided the house. They found a sex torpedo. Yeah, we know there's a couple of sex toys that were taken into evidence. Where was this found? Any unusual devices found? Found based on description given by girls. I'm assuming. Bunch of these. Present acquisition. I don't know. Dick gave Payno when Jeffrey redacted something. Who caused redacted Jeffrey? I don't know. Ooh. The direct continued. Bunch of these. Lucky L. I don't know. Who made direct appointments? I'm assuming he's just marking the passage of time or something like that. I don't know. Something's age. I mentioned something's age. Okay. Direct PBPD. I'm assuming there's police stands for Palm Beach Police Department there. Where went to on October address. New house was entered. I don't know. Detective redacted. Needs something addressed to appreciate entirety of lease or something. I don't know. Evidence description. Oh, fucking hell! This is Sorry, I'm trying the best I can. Residence description. Okay, witnesses description from attached. Witness description diagram. So like a diagram of the house, maybe. I don't know. Page 7. Found massage table. Again, found massage oils. So any massage aid found where massage table was. Okay, so they found the massage staff. They know that's there. I don't know what it says. Or witness something. Did any something... Fucking hell, what does that say? Okay. Tito direct. DR redacted continued. Who was in residence when warrant issued? So I know there was some members stuff there. Where was the torpedo found? Yeah, they keep mentioning the torpedo. It's the sex toy. So I'm assuming that was used on the girls. Unfortunately, yeah, pretty horrifying. But that's key evidence though. Damn, T-direct, nothing. Something because I've redacted. Oh, I can't tell. Redacted introduced went to Jeffrey. Went to Jeffrey's home. Not time or something. Oh no, yeah, was 16. 16 years old. Don't know what that says. Janice Gibb, maybe. Witness describes the time she went to Jeffrey's house. Jeffrey gave her $200. Okay. Knew any times went to Jeffrey's house. How massage something. Show me how many times did she massage him. Last time redacted. And I don't know. How old was witness? Again, I don't know. Told Jeff. Oh, she was asked how old she was. Told Jeffrey she was 17. Jeffrey redacted. How much age was paid? How much she was paid? Jeffrey gave her digital camera. Redacted was in something. Then my time. Jeffrey asked which attack. Redacted. Description with went Jeffrey to be charged. Did her father know about, I don't know, solicitation maybe? How much money did she get dating at that time? Dating is probably a bad way to put it. It was... How old was witness where redacted did this? Why didn't they ask Jeffrey's age? Or why didn't they ask Jeffrey to stop? TG Direct redacted. Police, something redacted. Bunch of redactions here. What is redacted? Witness name. Something redacted. Wanted to please to witness. Redacted. When it's ready from Exhibit C. Something. Date redacted. Makes reference to meeting to the something. I don't know. What was the date that she said she wanted to be... be actress. Or be actress? I think there was a witness that wanted to be an actress. Or one of the victims. Yeah. I mean, that's a terrible way of saying actress, though. Okay, this is a massive scribble. Fucking hell. Please help me. Oh, God, it does go on past page 9. I thought page 9 was it. Okay, this is a bunch of scribbles. Continued. Continuing investigation. Dead. Something, dated 4/25/06, ASA, ASA, oh no, that's, I think that's the, ASA, that's an attorney term. It direct, redacted. To direct continued, time of redacted, and that's the same here, is past time, redacted. Don't know what that says. That looks like a capital, so it could be a name. 6104. Redacted started. Redacted? Redacted. Something. Do redacted reflect? Redacted. Company's dates, maybe? No, United days, no. Fucking hell, I don't know. 52606 redacted. Out. Entered. I don't know. Did computer check for check on get redacted something date. Again, let's check year. 11/16/05. 5/27/06. A take of 25 across dating period. 17 years, 8 cleared. Or 17 years, 8 something, I don't know. Redacted. Played 3/20/06 legal. Something 5/24. God, this is hard. 8 cases. I think these are like things taken into evidence. So 8 cases during period handled by redacted. 14 something may have... I mean, I want to say these are probably CDs or DVDs. October's... this is redacted. Yeah, these are heavily redacted. And this is also heavily redacted. Fucking hell. That's nearly impossible to read, so I did what I could. So sorry about that. So, dataset 8 begins at file 9676. So we're on 9440. So I want to try and at least get I want to at least try and get what I've got coming sub 200. But I don't think it's going to be like as bad as what I had to deal with previously. As I say, I think next time I stream, I'll just stream until I've done dataset 7. Because it's not going to be as worse as what I just did. United States District Court, 7th District of Florida, in RE Operation Leap Year, copy, Federal Grand Jury 07103, West Palm Beach, Florida, May 8, 2007. Appearances, redacted, Esquire, Assistant United States Attorney, redacted, 4-person. Testimony of redacted. The sworn testimony of redacted was taken before the Federal Grand Jury, West Palm Beach Division, West Palm Beach County, State of Florida, on the 8th day of May 2007. Philip W. May, court reporter, was authorized to and did report the sworn testimony. Okay. The witness entered the grand jury room, redacted, having been duly sworn by the grand jury 4-person, was examined and testified on his oath as follows. Examination. By Ms. Redacted. Special Agent Redacted. Could you state and spell your name for the record? Redacted. Redacted. By whom are you employed? I'm employed by the FBI. What is your position with the FBI? I'm a special agent and have been so for 4 years. This better not be another fucking repeat, because this is a bunch of others started the same way. Okay, let's carry on. Are you one of the agents assigned to the investigation known as Operation Leap Year? Yes, I am. Were subpoenas caused to be issued on behalf of this grand jury in connection with that investigation? Yes. And have documents been received in response to those? Yes. What additional subpoenas have been issued, and what have you received in response? Additional subpoenas that have been issued include OLY28 Colonial Bank, along with OLY29, which was issued to the Palm Beach National Bank and Trust Company. This was served on March 5, 2007. It should be known that Palm Beach National Bank and Trust Company is now operated by Colonial Bank, which we learned in the insurance process. We did receive documents back from Colonial Bank, which covered both subpoenas on April 25th, 2007. So yeah, I'm gonna go up to this far and then I'm gonna stop. And those sought information related to bank accounts belonging to Mr. Epstein. That is correct. What else? Also served Ollie 30 to Western Union Financial Services, seeking documents and records related to Jeffrey Epstein. It was served on February 26, 2007, and we received items back from Western Union on 2 separate dates, in 2 packages, the first on April 9th, 2007, and the second on April 11, 2007. And those sought records of wire transfers from Mr. Epstein to girls who have been identified for this investigation. Yes. What else? We also served Ollie 31 to Western Union Financial Services. It was served on February 26, 2007, and they returned information which we received on May 3rd, 2007. The same type of information. Yes, the same type of information. Seeking wire transfer information from Jeffrey Epstein to victims. We also served Ollie 32 to JP Morgan Chase Bank. After serving that one on February 26, 2007, they informed us by letter that they are known as Chase, not JP Morgan Chase. So we had to reissue another subpoena, which was taken care of on March 22, 2007. We also issued Ollie 40 on Chase Bank, as well as on April 4, 2007. We received records on April 13, 2007, and April 19, 2007, to cover all 3 subpoenas that were served. And those sought information related to bank accounts and credit cards related to the defendants. Yes. Additionally, we served Ollie 33 on Dr. Thomas Rafrano, phonetic, who is a chiropractic doctor. We were seeking records related to Jeffrey Epstein as a patient. The subpoena was served on March 6, 2007, and Thomas Rafrano provided materials on March 16, 2007. Also, we have Ollie 36, which was served on the Palm Beach County Health Department. It was served on March 5, 2007, seeking perf certificates on our victims that we were researching. We received the records from the Palm Beach County Health Department on April 16, 2007. We also served 2 subpoenas on the Adult Video Warehouse. The first one was Ollie 41, which was served. Both of these were served on April 24, 2007. And they were seeking any transactions that had occurred on behalf of Mr. Epstein or those individuals that were working for him or with him. We received items back on the Ollie 41 subpoena on April 30th, 2007. The second subpoena served on Adult Video Warehouse was Ollie 34. Again, it was served on April 24, 2007, and the Adult Video Warehouse complied and provided us materials on April 30th, 2007. That concludes all of the items that we have received to date for the outstanding subpoenas that were issued. Are the documents that you refer to in that box that's on the desk? Yes, they are. Redacted. Does anyone want to review those documents? At this time, no one is requesting that they want to review the documents today. Would you please swear in the witness to maintain these documents? Witness sworn in as custodian of the records. Witness excused. Certificate of Reporter. I certify pages 1 to 6 is a true transcript of my shorthand notes of the testimony of Redacted before the Federal Grand Jury, West Palm Beach, Florida, on the 8th day of May, 2007. Dated West Palm Beach, Florida, this 28th day of May, 2007. Philip W. May, Court Reporter. Sorry if I sound like I'm going through that quickly, because yes, I am. Okay. This will be the last file, and then I'll go on to and then that'll be it. The next one, that's about 200 files, but that should be enough for, the next stream. Whew. All right, we got this. I think this is 30 pages long between that and that. So that's fine, I can do that. United States District Court, Southern District of Florida, NRE Operation Leap Year. Federal Grand Jury 07-103, West Palm Beach, Florida, February 27, 2007. Appearances: Redacted, Esquire, Assistant United States Attorney. Redacted, 4-person. Testimony of Redacted, original. The sworn testimony of Redacted was taken before the Federal Grand Jury, West Palm Beach Division, West Palm Beach County, State of Florida, on the 27th day of February 2007. Redacted, court reporter was authorized to and did report the sworn testimony. The witness entered the grand jury room. Redacted. Having been duly sworn by the grand jury foreperson, was examined and testified on her oath as follows. Examination. By redacted. Good morning, Special Agent Redacted. Could you restate and spell your name for the record? It's redacted. Can you remind the grand jury who you are employed by? The FBI. I know that you testified here a few weeks ago. Was there anything from that testimony that you wanted to correct? I did. I was asked by one of you, Mr. Epstein's age, and I confused him with another individual in another one of my cases. His birth date is January 20th, 1953. We are looking at the time period of 2004 and 2005. So, Mr. Epstein would have been about 51 or 52 years old, and I believe I told you he was 45. So at the time we're looking at during this investigation, he is 51 or 52. Agent Redacted, how did this case first come to the attention of the police? In March of 2005, Redacted, our youngest identified victim, her Redacted called the Palm Beach Police Department and reported that she believed that her stepdaughter had been molested by a male that resided in the town of Palm Beach. So today we are going to talk about Redacted. Yes. And we are using her initial to protect her identity, correct? Yes. Can you tell the grand jury Redacted date of birth? Redacted's birthday is Redacted. And you mentioned that the call came in from Redacted in March of 2005, correct? Yes. So how old was Redacted at that time? She was 14. Where does Redacted live? Redacted lives in the Redacted area here in Palm Beach County. At the time, in 2005, what school was she attending? Redacted. What year was she in school? She was a 9th grader there. You mentioned that her Redacted called the Palm Beach Police Department. What did the police department do in response to that call? They wanted to interview Redacted. I believe it was the next day they went out to where Redacted was attending school at the time, which I think was Redacted. They interviewed Redacted at Redacted and wanted to get her side of what took place. Because we'll be referring to this throughout. What was the name of the detective who conducted that first interview? Detective Redacted. So in March of 2005, Detective Redacted talked with Redacted. Was Redacted ever interviewed at any other times? Yes. She was interviewed. They talked to her again. She placed some control calls to them later that month. We will talk about that later. As well as she was interviewed about a year later in July of 2006. Not interviewed, but she testified before the grand jury for the state of Florida. So she was interviewed by Detective Redacted in March of 2005, and then about a year or 3 or 4 months later, in July of 2006, she testified before a grand jury with the state of Florida. In preparation for your appearance today, did you have a chance to interview Redacted? Yes, I did. And when was that? Last night. Back in March of 2005, you mentioned that Detective Redacted met with Redacted on or more than one occasion. Yes. If you could give us a sort of an overview of what Redacted reported during these interviews, and then if there are specific discrepancies or differences, we will return to those later. Alright. On February 5th, 2005, it was a Saturday, and Redacted was at Redacted's house. Redacted. She was there with her boyfriend, Redacted. And because these are minors, we'll refer to them without using their last names, so I'll use those initials. They were at Redacted's residence, and Redacted is Redacted's boyfriend, which is also Redacted's cousin. So they were all at Redacted's house, and Redacted was on the phone with an individual that Redacted refers to as the assistant. Redacted would describe the assistant as a tall blonde. So that might not be Maxwell then. So throughout, I'll refer to her as the blonde lady, if that's okay. Redacted was unable to recall her name, so Redacted is on the phone with the assistant for Jeffrey Epstein. Redacted and Redacted overhear Redacted on the phone describing Redacted. Redacted describing Redacted to the lady on the phone. So when Redacted gets off the phone, Redacted and Redacted both want to know why Redacted was being described to this lady on the phone. Redacted becomes upset when Redacted asks Redacted if she would like to go to Palm Beach and give a man a massage that she knows. Redacted agrees, and this upsets Redacted, and an argument ensues where Redacted and Redacted go into the bathroom and they argue outside the presence of Redacted. Let me stop you there. Was Redacted supposed to be paid for giving this massage? Yes. Redacted told Redacted that she would be paid $200 or $300, I believe. You mentioned that Redacted is Redacted, and Redacted is also Redacted, correct? Yes. What was Redacted's idea about why they were arguing? She told us that she believed that Redacted must have known what Redacted was doing for this man, and the work that Redacted did for Mr. Epstein, and that is why Redacted was so upset. So Redacted knew that this wasn't just a regular massage that was going to take place. Yes. So Redacted and Redacted have this argument. What does Redacted decide to do? Redacted decides to go. Because she wanted to make the $200 or $300? Yes. So tell us then what happened after that meeting. The next day, February 6th, They discussed that evening about going the next day. We do have on redacted phone records 2 calls that were placed. One was placed to Redacted's cell phone, and the other was placed to Jeffrey Epstein's residence the night of February 5th. The next day, Redacted is contacted a couple of times before Redacted arrives. Each time prior to Redacted being contacted by Redacted, a call is placed by Redacted to Redacted's cell phone. Redacted, I should tell you, is Jeffrey's assistant. So on Sunday, a call was placed to Redacted, and then shortly after that call was made to Redacted. That same series occurs again, but this time Redacted places a call to Mr. Epstein's residence, and then Redacted is called again. Eventually, Redacted comes to Redacted's residence with another girl in the car, Redacted. So the 2 of them arrive at Redacted's residence, and they continue over to Mr. Epstein's house. Sorry, my legs are stiff. I've been running for about an hour and a half earlier today, so yeah, legs are very, very stiff. Especially my ankles. God damn, they hurt. Redacted is driving with Redacted and Redacted. Do you know how they were sitting? You know, I'm not sure how they were sitting, but I know that it was a pickup truck that Redacted drove, and Redacted was the driver. I'm not sure exactly the placement of the other 2 girls, but they were in the truck. And Redacted was able to describe how they travelled to the island of Palm Beach? Yes, she gave directions, the best that she could on how she was able to come to Mr. Epstein's residence. Once they arrived at the residence, what happened? I should have mentioned that either the night before or the day of, there were some things that Redacted tells Redacted. One, she tells Redacted that she is to tell, if asked, that she is 18 years of age, that she attends high school, that she's in the 12th grade, and I believe it was Redacted that she was to say that she went to. Talking to Redacted last night, Redacted told us that once she arrived at the residence, Redacted tells her that she may possibly be asked to take her clothes off. She also tells her that she can stay in her bra, but she may be asked to take her clothes off. And Redacted told us last night that that's when she knew for the first time that she might have to possibly remove her clothes. At this point, they proceeded to enter the residence. Redacted describes him as a security person. He approached and asked what they were doing there, and Redacted said they were there to see Mr. Epstein, or see Jeffrey. He allowed them entry into the kitchen area by the pool, and Redacted describes that area. So now Redacted, and Redacted are all sitting in the kitchen. A short time goes by, and Mr. Epstein, as well as the assistant, enter the kitchen. And I know that you mentioned that Redacted did not know the name of the lady who was there in the kitchen, correct? Right. She just described her as a blonde, tall lady. Yes. Was Redacted also interviewed about what happened that day? She was interviewed by the Palm Beach Police Department. Did Redacted identify the person who was on the phone with her as Redacted? Yes, she did. So even though Redacted doesn't know her name, Redacted knew Redacted's name? Yes. So you mentioned that the 3 girls are in the kitchen, along with Jeffrey and the person Redacted calls the blonde lady? Yes. What happened then? Redacted follows the blonde lady upstairs to Mr. Epstein's bedroom. The blonde lady proceeds to take out a massage table and set it up. Prepare it. She also takes up some lotions to be used during the massage. Redacted told me last night that the blonde lady asked her to remove her clothing and then left the room and said that Mr. Epstein would be in shortly. What happened after she left the room? Shortly after that, Mr. Epstein does come into the room and shakes Redacted's hand. Redacted told us last night that Mr. Epstein told her to remove her clothing. He leaves the room and comes back in just a towel, and he tells her again to... She is at that point when he walked, in the first time she had on her bra and her pants. When he comes back in, he tells her that she needs to take her pants off. So she took her pants off. So now she's in her bra and underwear. Fucking cunt. At some point, did Redacted tell any of the people who interviewed her what was running through her mind? She stated at one point that she was upstairs with him, with the man, and that Redacted was downstairs. I guess she says, what could Redacted do? She's downstairs. I'm upstairs. So she did what she was asked to do. So now you mentioned that Mr. Epstein is here wearing just a towel, and Redacted has removed both her shirt and her pants, is that correct? Yes. Tell us what happens then. Mr. Epstein gets on the massage table, lying on his stomach, and instructs Redacted how to do the massage. He tells her to put some lotion on her hand and instructs her on how to actually perform the massage. At one point during the massage, he tells Redacted that she'll be more comfortable to get on top of him. So Redacted gets on top of him and straddles Mr. Epstein's back. The way Redacted describes it is that Mr. Epstein is laying on the table. He has a towel covering his bottom, and she is straddling him with her bottom touching the towel and some skin touching his lower back. She was kind of sitting, it sounds like sitting on his rear end, but with part of her skin touching him, the front of him, but he has a towel across his bottom. What happens as she is providing the massage to his back? The massage goes on. She said the entire massage lasted anywhere from 30 to 45 minutes. At one point, Mr. Epstein excuses himself for a few minutes. 1 or 2 minutes briefly. Redacted states that she can hear Mr. Epstein... Whoa! Dexter? Dexter fell off the desk. He was getting a little bit too comfortable and rolled off. Oh, God. Dex! You scared Clara as well. Hello, Clara. You alright? Hello. Alright. I'll tell you what. Oh my God. That's getting clipped. Somebody clip that. Oh wow. That scared the shit out of me. Hello, Clara. Clara's on the floor here. I tell you what, at the end, I will also get the treats out because they've been good. I'll get them treats. I'll show you how I feed them treats on the stream because they will jump up and around all over the place. Oh Jesus. And now I can hear Dexter meowing outside. Well, I tell you what, if I put my headphone stand there, that will sort of better hold this in place. Yeah, I think Dexter rolled off, but he did grab the blanket with him. He stuck his claws out in a panic, so yeah. Dexter! Oh. Well, Clara's now lying down on the floor, so she's fine. It did scare her, though. Alright, where was I? The front of him, but he had a towel across his bottom. Okay. What happens as she is providing the massage to his back? The massage goes on. She said the entire massage lasted anywhere from 30 to 45 minutes. At one point, Mr. Epstein excuses himself for a few minutes, 1 or 2 minutes briefly. Redacted states that she can hear Mr. Epstein redacted, and states that she believes he was, in her words, redacted. She didn't say redacted, she said redacted. I'm going to use that she believes he was redacted. Then he returns. At this point, he gets back on the table, lying on his back, and asks her to start massaging his chest. So she begins to massage his chest. Does he keep the towel on? No, at this point the towel is removed. When he comes back and he gets back on the table, the towel is removed and she is massaging his chest. What does he do as she is massaging his chest? He redacted. So he redacted on the table. He asked Redacted at some point during this time if she would like to make an extra $100. He tells her that it would not involve doing the massage. Redacted agrees. He asked her if he could redacted, and she does agree. Redacted describes it as a redacted, and she said this goes on for about 10 minutes. At some point during that massage, Redacted describes him redacted. What did she say happened to when Mr. Epstein redacted? The redacted. At some point he does redacted, and these are her words. She looks at him kind of funny, and he sarcastically, which is her word, he sarcastically says, "What's the matter?" And she at that point just kind of looks away. And he continues on with redacted. In the last 3 to 4 minutes of that, he redacted. In the conclusion of the sexual activity, Mr. Epstein redacted. Redacted was asked if redacted. She redacted, but saw him redacted. Was redacted able to provide a physical description of Mr. Epstein? Yes. Including of redacted? Yes. Was she also able to provide a description of her surroundings in that massage area? Yes. Was that description accurate? Yes. According to other testimony we have gotten from other victims, yes. And a search was performed on Mr. Epstein's house? Yes. The Palm Beach Police Department did perform a search, and several of the items that were described were found in the house. After Mr. Epstein redacted, what happened? He told Redacted that she was getting the extra $100 because he was allowed redacted. The massage had been concluded. The sexual activity had been concluded. He gets up and leaves for a brief moment of time and comes back with $300 and pays Redacted the $300. I believe he told Redacted that she could see herself out. Before we leave that room, when Redacted was either being directed to the room or was inside that room where the massage took place, was there anything in particular that she noted seeing? She noted seeing several naked pictures of girls in the room, a mural of pictures of naked girls either exposing their breasts or completely naked. While the massage was going on, did Mr. Epstein talk to Redacted? Yes, he did. And did he talk about sexual conquests with girls? Yes, he did. Once Mr. Epstein has provided Redacted with the $300, what did she do? She went back downstairs and she Redacted and Redacted leave the residence. In the car they ask Redacted how much money she has made, and she tells them $300. Redacted wants to see the money. She shows the money to Redacted, and Redacted asks what did she do. At that point Redacted tells her that he redacted. When they left the house, where did they go? When they left the house, they were on their way to a mall to go shopping with the money that they had received from Mr. Epstein. Redacted had told Redacted the night before that she needed some shoes and wanted to go to the mall, and she was going to Mr. Epstein's to pick up some money. There was another reason that she had for going to Mr. Epstein's house that day, and that they were going to go shopping after she got her money, and that Redacted could make some money. During that ride, did Redacted realize that Redacted received money from Mr. Epstein? Yes. At some point, Redacted knows that Redacted received $200, but is unsure that Redacted ever gave a massage. So at that particular time, Redacted did not know why she had gotten the $200, because she didn't think that Redacted had had time to give a massage. In Redacted's interview, did she explain what she got the $200 for? Redacted told the Palm Beach Police Department in her interview that she received her $200 for bringing Redacted to the house. You mentioned that there were these 3 different time periods that Redacted was interviewed, shortly after the events, at the time of the state grand jury proceedings, and when you met with her, correct? Yes. And there were some discrepancies between the different interviews. Can you explain some of those to the grand jury? Before we go and get to that, I want to make sure that when we discuss what Redacted was told in the car by Redacted, that we learn from Redacted's interview with the Palm Beach Police Department. So I don't know if I said that, but I want to make sure you know that we first learned that Redacted by listening to the interview that was conducted between the Palm Beach Police Department and Redacted, not from Redacted. When I talk later, I just want to make sure you realize that had not initially come out in Redacted's interview, but through the interview with Redacted. So going back, discrepancies? Yes. I met with Redacted last night to discuss some of the discrepancies when looking at what she had talked to Detective Redacted about in March of 2005 and what she had testified to in the grand jury in July of 2006. Reading the testimony and listening to the tapes, or reading the transcript, there were a few discrepancies. One of the first ones we talked about was what Redacted had told her about going to Mr. Epstein's house. She tells Detective Redacted that she was told about the massage, told about getting $200, but that she was not told that she would have to take her clothes off. She didn't know she would have to perform the massage naked. When I asked her last night that question, she told me that when she got to the house prior to going into Mr. Epstein's residence, that Redacted did tell her that she may be asked to take off her clothes. She also did state that Redacted told her she could stay in her bra. So I wanted you to know that there was a discrepancy in what she originally had told Detective Redacted and what she told me last night. That would be one. The second discrepancy I wanted to touch on with her was going upstairs and taking off her clothing. When she is in that room, she states to Detective Redacted that Redacted asked her to remove her clothing, and she took off her shirt. Then Mr. Epstein came in the room, shook her hand, and told her to take off her clothes. He leaves, he comes back in a towel. He tells her again. Redacted tells Detective Redacted in a stern voice, Mr. Epstein told me to take off my pants, because she hadn't taken off her pants from the first time that she met him. In her testimony with the grand jury with the state, she tells the grand jury that it was Redacted who asked her to remove her clothing. So last night we went over with her who told her to remove what. She had a very hard time recalling exactly. She knew she had gotten down to her bra and underwear, and then at some point, when we're going through the sexual activity, she actually tells me that her underwear was off when he was Redacted. Fucking Christ. Later in the interview, we tell her about what we have in her testimony to the grand jury and her statements made to Detective Redacted. And she really is having a difficult time trying to remember who told her to take off her clothes and her pants. As we are walking for the sexual activity, she does recall and states that it was Mr. Epstein who told her to take off her pants. I guess I'll go to the third discrepancy. Is there anything I left off of that? Well, does she report that when the assistant leaves, or the blonde lady leaves her upstairs, that the blonde lady also said, get undressed, but that Redacted didn't get fully undressed? That's what she said in her statement to the detective, when she gives her first statement. She tells us again last night that that's what she recalled. That the lady first said, get undressed, but she doesn't get fully undressed. When Jeffrey comes back, he says, take your pants off. Yes, and again, like I said, when we started interviewing her and asking her about this, she did have a hard time. But when we were walking through the sexual activity, that's when she recalls who told her to take off her pants. And I'll tell you, when we talked about the sexual activity and it comes out that she wasn't wearing her underwear when Redacted, she does not recall how they came off. She cannot remember removing her underwear. She doesn't remember if Mr. Epstein removed her underwear. She knows her underwear was off, but she cannot tell you exactly at what point her underwear was removed. Let's talk about the third discrepancy. The third is the sexual activity, when she was originally interviewed by Detective Redacted about the Redacted. When Detective Redacted comes and sees her again a few weeks later, she does tell her at that time that Redacted. She also says that to the grand jury. She talks about the Redacted. Last night she told us about Redacted. When we asked her about him, Redacted, and that Redacted had told the police department that she Redacted. Redacted told us last night that she Redacted by Mr. Epstein, but that she thought only her and Redacted knew about this, and that she did not want her father to know that Redacted. She didn't want anybody to know, but she especially didn't want her father to know, that was her business. that she did not know that Redacted had told anybody. She thought it was only her and Redacted that knew. She was embarrassed and didn't want anybody to know that. Did she become visibly upset? Yes. She began crying when we asked her about Redacted. When she realized that we knew about that, she became very upset and concerned about her father. She mentioned that her father has read a lot of the reports in the state of Florida and has followed the state's case. She was concerned about even telling us, afraid that he would be able to read in our reports about this. We explained to her that the FBI's reporting is a little bit different than the way the state. Those are public records, and ours is part of our case file. In addition to the fact that she had these concerns about her father, and she was embarrassed, in your experience of interviewing... Oh no, sorry. That's a question. In addition to the fact that she had these concerns about her father, and she was embarrassed, in your experience of interviewing victims of sexual abuse, is it typical for them to not disclose all of this sexual activity? Yes, it's very typical. And young girls, they don't want to talk about it. This is just another case of her not wanting to tell exactly what took place. After that first visit to Mr. Epstein's house, and the interviews with Detective Redacted, did Detective... Is this the right page? It's page 22, this is page 25. We fucked up somewhere. Alright. Yeah, this is 23. Redacted asked Redacted to make what are called control calls? Yes. Can you explain to the grand jury what a control call is? A control call is where we actually have a listening device, where we have an individual place a call to somebody, and we are able to record the other person's voice and the conversation that takes place between the person that we're having make the call and the person that they are calling. Who did Detective Redacted ask Redacted to call? Redacted was asked to call Redacted on the phone. And did she do so? Yes, she did. Can you tell the grand jury when the calls were? I believe the first call was made towards the end of March. I believe it was March 30th. Redacted called Redacted at the Olive Garden where Redacted works. Redacted was concerned that Redacted's father had found out somehow and that they knew about it, and she refers to him as Jeffrey, but Mr. Epstein. Redacted told her that they did not know about Mr. Epstein. Later in the conversation, Redacted tells her that Mr. Epstein would like her to come back and work for him, and that maybe she could work for him tomorrow. So they agreed that there will be a call between Redacted and Redacted tomorrow, that Redacted will call Redacted tomorrow. Were their calls also made on March 31st of 2006? Sorry. Hey, Chloe, you alright? A. There were 2 calls made on March 31st. The first one, she doesn't connect to, Redacted. The second call that was made a short time later, Redacted answers the phone. Again, there is a discussion about Redacted coming to work for Mr. Epstein. Redacted tells Redacted, one of the comments that is made is, the more you do, the more you make. Hey. Redacted is asking her how much I can make. Again, Detective Redacted is there, and Redacted is asking, nope. Clara, you're going to behave. Oh, you do that. Again, Detective Redacted is there, and Redacted is asking Redacted, how much can I make? Redacted is telling Redacted that she'll have to ask Mr. Epstein that she is going to see Mr. Epstein tomorrow, and that she'll talk to Mr. Epstein. There is conversation about Redacted and her twin sister possibly coming to Mr. Epstein's house. There is some discussion about her coming to work for Mr. Epstein. Just so it's clear, because there was a lot of she's, Redacted is telling Redacted that Redacted is going to see Epstein the following day. Yes. And that Redacted is going to set up a schedule with Mr. Epstein for Redacted and her sister to work with him. Yes. Alright, let's go back to page 25. Okay. On April 1st, the following day, did Redacted make calls to Redacted? From the Palm Beach Police Department, they were able to take voicemail messages left by Redacted on Redacted phone, stating that Redacted could come and work on Saturday around 11. I think you mentioned this last time, but in case you didn't, did the Palm Beach Police Department do trash pulls at Mr. Epstein's house? Yes, they did. Was there anything of value related to this series of calls that were recovered? Yes, there was a trash pull done in the beginning of April, and in the trash there was a piece of paper that on it had Redacted's name, and I believe it was 10:30 listed on the piece of paper. It said Redacted with Redacted on Saturday at 10:30? Yes, it did. In addition to the actual recordings of those phone calls and voicemail messages, do you also have telephone records from both Redacted's cell phone and Redacted's cell phone that match up? Yes. Just to go back to something that you mentioned, who actually gave the $300 cash to Redacted at the day she was at Mr. Epstein's house? Mr. Epstein. You mentioned a girl named Redacted. Yes. Was Redacted also interviewed? Yes, she was. Was she asked about going with Redacted to take girls to Mr. Epstein's house? Yes. Was she asked who the youngest looking girl was? Yes. What did she say? She discussed Redacted looking young in her interview with the Palm Beach Police Department. Redacted. Those are all of my questions for you now. If you could please step outside, I'll see if the grand jurors have any. Witness excused and then returned. By Redacted. Agent Redacted, we have just a few questions. One relates to the conversation between Mr. Epstein and Redacted about his exploits with other girls. Did Mr. Epstein say anything about the age of those girls? He said that, in particular on one case, he talked about a young girl that was in the back seat. Page 37. With, and her parents were in the front seat. He told Redacted that they were having sex in the back seat, were doing sexual things in the back seat while he was carrying on a conversation with the parents in the front seat. I guess they were on their way home from a business party. This was one of the stories that he had talked about. But at no time did he provide any specific ages about any of those girls. No. What was Redacted's age at the time she took Redacted to Mr. Epstein's house? She was 18. Did Mr. Epstein ask anything about her age? He did. He asked her how old she was. She said she was 18. He asked her what grade she was in. She said she was in the 12th grade. He asked her where she went to school, and she said she went to Redacted. I know we will be doing a lot more discussion about Redacted later, but could you tell us briefly how Redacted was recruited to go to Mr. Epstein's house? Redacted was at the beach, and two individuals approached her about making money and giving a massage to Mr. Epstein. How old was Redacted when she first went to Mr. Epstein's house? Through phone records, we have contact between Redacted and Redacted starting at age 17. Oh, bless you. Clara sneezed there. Redacted. Those are all the questions. Thank you. Witness excused and then returned. By Redacted. The question was there any particular evidence to suggest that Mr. Epstein knew that Redacted was under the age of 18? I would say through the interviews of the multiple girls that went to Mr. Epstein's house, the way that, having seen Redacted last night, and now she's 16, this was 2 years ago, that Redacted's age and behaviour, and again, is that more circumstantial evidence? As far as concrete evidence, no. But just by her appearance and her mannerisms, and how I observed her last night at age 16. Q. And that's consistent with what Redacted said during her statement, correct? Yes, it is. Ms. Redacted. Any other questions? Juror. Did she look 18? The witness. Does Redacted look 18? Not in my opinion, sir. Ms. Redacted. Clara. All right. Any other questions? Okay, thank you very much. Witness excused. Certificate of Reporter. I certify pages 1 to 28 as a true transcript of my shorthand notes of the testimony of Redacted before the Federal Grand Jury, West Palm Beach, Florida, on the 27th day of February 2007. Dated at West Palm Beach, Florida, this 18th day of March 2007. Philip W. May, Court Reporter. And that's a blank page here. And that's indeed where we are looking to end things this evening. Let me just have a look at the chat. Crimson Fox. Crimson Fox Onuse 4472 is now a member. Thank you very much. Memberships do actually support me directly, and it does give you early access to future chapters of our ongoing series. Okay, that scared the shit out of me. Kitty scare. Absolutely. Hello, there he is. Oh shit, wrong direction. Can you see him? Dexter's back. There we are. Absolute clumsy cat. And Clara is right by my mic there. So now, yeah. Well, if nobody's clipped that kitty scare, I'm going to do so because that was quite funny. And I'm also going to compile everything for the US attorney's like full deposition. That's going to be like a 6-hour, 7-hour VOD. You know, a lot of people probably aren't going to watch that, but that's going to, you know, that's a bit of history that we're going to preserve there. So I'm going to give my cat some treats, and you should hopefully see them have fun and run about. So I'm going to get my chair out of the way so you can see it. Let's end on a light note. We're going to end on a light note. Let's get that out of the way. There we go. Alright. You've been very good, haven't you? Both of you have. Even you, Clara. Even though you are normally the bane of my existence. Yes, you are. Here's your good kitty. Now, Dexter, come up here. Let me pay for your treats. I've also got to make sure it's an even amount between them because I don't want to have favourites. Oh, fuck. Alright. 3 treats each. There you go. Hey, hey, Dex, here we go. And there you go, Clara. Oh, hang on, you're right. Yeah, that went down quick. Alright. And that was that. Not available to clip, that's fine, I'll do it myself. Because all of these streams are saved on the channel. Wow, 3 hours and 15 minutes, and it is 11:15 at night. So yeah, this is a good time to end the stream. And I can go to sleep because I've got a bunch of videos to record for tomorrow. But I got power armor out pretty quickly at least, so that's good. Anyway, ladies and gents, it's been fun. We did well. My throat is mostly okay, actually. So yeah, it's just, you know, I've got to take a break, and it's getting late in the evening. Oh, hello, Clara. No, there are no more treats there for you, little kitty. No, but I have given them food, and I've given them crunches downstairs, so that's fine. Anyway, thanks, guys. I don't know when I'm next going to stream. It probably won't be tomorrow, unless our tabletop game is suddenly, you know, suddenly cancelled. I might do it, like, I might test something and do it, like, midday during the weekend or something. But I do sort of want to get the next stream done sooner rather than later, purely because that means we'll finish dataset 7. And I can make a start on dataset 8, which is apparently going to be a little bit longer. So, you know, it is what it is. But I think we did very, very well today. And as I say, I'm glad we got that deposition finished. But yeah, ladies and gents, thank you very much.